3, 2, 1.
I don't hear anything.
Chairwoman, we're not able to hear you.
Please let me know if you can hear us.
It's working out. It's shaking.
Okay.
Here, yes, thank you. We'll resume again. I don't know from when we weren't heard, but again, I want to thank all of you for joining us this evening for our Board of Commissioners meeting, this January 25th, 2002. As with most of our virtual meetings, we start off with a moment of silence and ask for you to join me in remembering the life and service of our former chair, Mike Boyce, who received devastating news that he passed away today. But for those of you who are willing and able, please join me in a moment of silence. Thank you. We will now rise for our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Our meeting is now officially called to order. Our first matter of this meeting is to conduct a public hearing to address comments and inputs for amendments to our county code. I will turn things over to Jessica Gwynn, who is the director of our Department of Community Development.
Good evening, everyone. Jessica Gwynn, Cobb County Community Development. This evening, we will do the first public hearing for the 2022 Code Amendments package. We had a rather lengthy presentation this afternoon at the Board of Commissioners work session, and this evening we will also present those code amendments for public hearing. So we will start off with Chapter 6, and that'll be amendments to the alcohol ordinance. Those amendments will be presented by Sergeant Kevin Ashbaugh of the Cobb County Police Department.
Thank you, Jessica. All right. I'm Sergeant Kevin Ashbaugh with the Cobb County Police Department Regulatory Services Unit. And in Chapter 6, alcoholic beverages, we made some proposed amendments to the definitions to clarify county ordinances related to alcohol sales. We've updated some additional terminology used in the alcohol industry and defined some terms that weren't previously defined in the ordinance, such as approved container regarding to-go sales of alcoholic beverages, which are now allowed under state law. These changes include also defining mixed drink and package as used in this code section, but not previously defined as well. In Article 3, licenses, we've offered some updates to section 6-87 through 6-147. These have been updated to allow enforcement of this part against unlicensed businesses, where the existing ordinance only applied some aspects to businesses that possessed the alcohol privilege license and prevented us from citing businesses that were not licensed to do that. Section 6-104 is, we suggest repealing part of that code section requiring businesses to display their alcohol license information on the front glass of the business, and just retain then the requirement to post their business license inside the business. Section 6-147, we suggest an update to allow us to suspend or revoke a license when an applicant was used as a guise or dummy for another individual who was ineligible for an alcohol privilege license. Currently, if we find out during the background check process for the license, we can deny it. But once the license is issued, it is not considered due cause for the suspension or revocation of that license. If you look at Article 4, operating regulations, we've made some minor updates here. Particularly Section 6-176 has been updated to reflect changes in state law regarding to-go sales of alcoholic beverages. The state code was changed in 2020, and also to stipulate restrictions on such sales to ensure there's no sales to underage persons or irresponsible sales there. Section 6-179, we're recommending updates to more clearly define areas where alcoholic beverages may be sold, and the requirements for those sales at amusement parks that are licensed under this chapter now. Under Division 3, employees, we've suggested some amendments to Section 6-206 to more clearly define certain disqualifiers related to citizenship status, as well as clarify disqualifiers for persons who are on parole, probation, or have been convicted of certain offenses, particularly sexual offenses, which was not specified before. Section 6-207 adds an exemption from the work permit requirement for peace officers working secondary employment as security at businesses which serve alcohol or sell alcohol. Previously, or currently, the code section requires all persons working security to get a work permit from our office. And this will just streamline that. It's not been a practice to do that in the past for actual police officers that are working there. Continuing in Section 6-207, we have changed some language. Previously or currently, the licensees are required to provide information to their employees. We are changing from information to training for their employees, and we're specifying a 10-day time frame after employment that they have to do that. It also required regular information be provided, but was not defined. We've changed that to provide annual training thereafter once they're employed. It adds requirements for licensees to make their training records available to the police department upon request. Currently, it is only to the business license office, I believe. Also, in subsection E, we have recommended some guidance for the actual permits, work permits that are issued with specific physical characteristics and minimum information requirement. Also, to allow for the issuance of temporary work permits by the police department in certain circumstances where we may not be able to get that person's criminal history in a timely fashion, or they may not be available to be photographed. Section 6-209, we're recommending that it be amended to require licensees to furnish list of new employees after the license is issued anytime that they hire someone to submit that information to the police department within 72 hours of any change. Under Article 5, Section 6-236, this has been rewritten in specifically regarding to-go sales of alcohol and the sale of flights of alcoholic beverages, so that the flights would not violate the 2-drink limit currently in county ordinance. This is because flights are frequently sold as a way for customers to sample several different types of an alcoholic beverage, and this currently would be a violation of that 2-drink limit. And then finally, section 6236C10, we just update that to add one of the exceptions for state law to allow for the removal of alcoholic beverages from the premises when sold as a sealed to-go drink, again, to mirror the 2020 change to state law. And that concludes the amendments for chapter 6.
Thank you. Jessica, I'd like for us to go through all of the presentations and then we'll do the public comments or public participation in the hearing after all of the presentations.
Yes, ma'am, that sounds wonderful.
Okay, thank you.
So the next change that we'll be covering this evening is an amendment to Chapter 18. This is the building regulations section or chapter of the code. Section 18-27 currently requires an additional review of homes that are being torn down and rebuilt, so those infill properties. Previously, when this code was drafted, the review was not conducted by stormwater management to really look at the impact of the oversight or of the grading and drainage on neighboring properties. At this point, that review is redundant, so we are proposing to remove this language from the code in order to streamline our permitting process for those tear down rebuilds of single family homes. And the next presenter will be Drew Ressler with Chapter 50.
My apologies. For Chapter 50, the one recommendation that is being presented here is currently for land disturbing activities, no traffic study is required. And so the item here adds a requirement for larger developments that are coming in for a land disturbance permit to receive traffic, to require a traffic study. The one item that we will be looking at based on the public comment received is the definition of trips. The intention of trip ends was to more clearly define what a trip is. That intent did not appear to come through, and so the department will be working with the Attorney's Office and Community Development to better define exactly what a trip is and to make sure that it is consistent with the trip generation manual as well as ITE standards. That concludes DOTs for Chapter 50.
Thank you, Jessica. We can have the next presentation.
Yes, the next presenter will be Lieutenant Vance Dupree of the Cobb County Police Department.
Good evening. My name is Vance Dupree, and I'm currently the Administrative Services Lieutenant for the Cobb County Police Department. I appear before you today to present proposed changes to the noise ordinance contained in Chapter 50, Article 7 of Cobb County Code. The Police Department is primarily responsible for the enforcement of the noise ordinance. Section 50-256 utilizes a distance measurement of 100 feet to determine if a violation exists. If the noise is plainly audible from that distance, a Cobb County police officer may take enforcement action. This action could result in a summons to appear before the Magistrate Court of Cobb County. The proposed changes would alter the determination of a violation based on distance by amending it to a decibel metric. A decibel is a unit of measurement for sound. A-weighted decibels, abbreviated dBA, are an expression of the relative loudness of sounds in air as perceived by human ears. This logarithmic weighting closely resembles the loudness perceived by the human ear. The A-weighting network is preferred for adjusting the actual sound spectrum to one more like that heard by a person. This weighting is the result of much research, is commonly used, and is the proposed weighting for a noise ordinance. Under the proposed amendments, the proposed violation thresholds differ depending on time of day. From 7 a.m. to 11 p.m., the threshold for violation would be 65 dBA. The threshold for violation lowers to 60 dBA from 11 p.m. to 7 a.m. 60 decibels is a normal conversation between two people from 3 feet away. For reference, a 5 decibel increase is perceived as 1.4 times louder by the human ear. These levels match what is currently used by Marietta and Kennesaw for residential and commercial areas. Other agencies like Smyrna, Powder Springs, Austell, the City of South Fulton, Sandy Springs, and Johns Creek use similar decibel thresholds in their ordinances. Should the proposed change to decibels be approved by the board, the police department would need to be authorized to purchase certified handheld decibel meters for enforcement. These meters would provide the readings necessary to take enforcement action and provide evidence to be used in court.
Thank you, Jessica. I perceive we're queuing up our next presenter.
Yes, the next presenter will be Chief Nick Dahl of the Cobb County Fire Marshal's Office.
Hey, Jessica, give me just 1 second to share my screen.
Hey, Jessica, this is Lieutenant Dupree. I was having some difficulties. I have a little bit more left while Nick's getting ready.
Okay. No problem.
I'm still having issues with my slide, but section 50-257 enumerates prohibited noises. For all but 2 acts in this section, time and distance requirements are removed to be compatible with section 50-256. Construction and repair of buildings as well as associated noise is only permitted between 7 a.m. and 9 p.m. Monday through Saturday. The act encompassing landscape equipment like mowers, weed eaters, and leaf blowers remains the same as adopted last year by this board, which expressly prohibits these activities daily from 9 p.m. to 7 a.m. Section 50-258 provides exceptions to the noise ordinance. Exception A sought to preserve licensed activity under existing ordinances. The word previously was added to address any potential uncertainty with future zoning ordinance amendments. The current ordinance works well. These proposed changes would provide a metric for measuring noise nuisances, as well as align Cobb County's ordinance with other government partners. This time, we would request more time to continue to review and research the decibel-based enforcement approach. Should the board decide not to move forward with these proposed changes, any recommendations received will be considered for a modified proposal for the next code amendment cycle change. I respectfully appreciate your time in hearing the proposed amendment changes. Thank you.
Thank you, Lieutenant.
Hey, can you guys hear me? Whenever that happened, I lost the ability to share my screen. So,
We can hear you.
okay. Can you see my screen?
Yes, we can.
All right, give me 1 second. All right, I'm ready when you guys are. Should I just start?
Please, yes, go right ahead.
All right, well, first I'd like to thank the chairwoman and the board of commissioners for the opportunity to present this evening. Introducing myself, my name is Nick Dahl. I'm the division chief of the Cobb County Fire Marshal's Office, and I'm also the county fire marshal. Today I'm going to be proposing 7 quick code amendment changes. First is section 54-51. What the fire marshal's office here is intending to do is add expiration to permits with inactivity. There's also going to be an opportunity for people to renew them by staying in contact. And I did want to point out that the green section of the screen is actually a typo that was submitted. It read about, but it should have been above. 54-51.2. The fire marshal's office is proposing mandatory pre-construction meetings when projects have complex situations or inexperienced contractors are present. And we will be working with the Builders of Quality Growth to add in some language regarding experienced contractors not necessarily having to have the pre-construction meetings. Outdoor operational permits is in section 54-54.2. The fire marshal's office is proposing outdoor social gatherings with projected occupant load crowds exceeding 1,000 or 1,000 persons to obtain a permit. This is already in other sections of the county ordinance. This just clarifies and simplifies the way that we would require and review EMS service, hydration stations, and other crowd management techniques. Section 50. Go ahead. Sorry, I had feedback. Section 54-55 is just deleting section E, which later on in my presentation I'll show you is an appeals process for decisions made by the fire marshal and the fire marshal's office. In section 54-56, we're modifying the definition of the term fire code to include NFPA 1, which is the National Fire Protection Association's fire code. It's also adopted in Georgia, but it would be blended with the International Fire Code. It would be the two codes under one term. Let's see. Section 5481, we're going to continue on to the next page. We're adding a definition for fire protection contractor. We've always had one for sprinkler contractors, but we will be adding a definition that defines all the individual trades related to fire protection. Getting close to the end here, section 54-84, we want to include a proposed operational permit. I do want to point out that it comes at no charge. This is something the fire marshal office wants to do to be able to connect new businesses to Cobb County with licensed, compliant contractors. And we plan to host these vendors on a list on our website to help make things speedy for new businesses coming to Cobb. Section 9 is an entirely new section that was crafted by county legal. It deals with fire prevention and protection safety ordinance for the appeals of any decisions made by the Cobb County Fire Marshal's office. When you're dealing with new construction, there is already an appeal process through the state fire marshal's office, but existing buildings and other remodel projects will have a section 54-119. We're going to prescriptively follow section 119 appendix A of the International Fire Code, and all the way A through G will be the requirements on how the board will be set and the qualifications for the members. The records and procedures are just that. It talks about when the board would come together, and our efforts have been as best as possible to try to mirror our use of the International Fire Code to match the building department's current new construction appeal process. And that concludes my presentation for today.
Thank you.
Thank you, Nick. And I will present next on the code amendments to Chapter 78. So we have two amendments here to discuss right now, and there will be some more amendments to Chapter 78 forthcoming. The first amendment is to Chapter 78-1. This is definitions. We are proposing to remove the exemption for the first $25,000 in annual gross receipts from the rental of real property in calculating the occupation tax due. This will not apply to single-family residential. Any receipts that are from the rental of single-family residential will continue to be exempt from calculation for the occupational tax certificate. The next amendment is Chapter 78-43. Currently, we have a separate process for businesses that are changing location or ownership, but to streamline our processes, these will now be handled as a new application for the sake of our processing in our office. And next we will have, again, Sergeant Ashball to talk about additional amendments to Chapter 78.
Thank you, Jessica. All right, in this section, we were primarily doing this to address human trafficking and specifically sex trafficking. And so what we've done is the ordinance was kind of incomplete, so we've added some stuff to it and changed some things to specifically target that human trafficking aspect. There is a well-established link between sex trafficking and massage parlors. I think we all know that. And human trafficking involves the trafficking of persons for labor and or sex. According to the State Department, almost 25 million people worldwide are currently enslaved in forced labor. And almost 4.8 million of these are specifically in forced sexual exploitation. According to Forbes, illicit massage activity or prostitution, other sexual services in America accounts for an estimated $4.5 billion annually, which is about 1/4 of the $16 billion a year massage industry. Human trafficking is at an alarming level in Metro Atlanta and Cobb County. I know we don't like to acknowledge those things or think that we have them, but we do. And human traffickers are known to frequently move their victims between business locations and residences to make it harder to track and locate them. They'll take the victim's identification and immigration documents to make it difficult for us to identify those victims when we encounter them, and also to discourage those victims from coming forward for fear of deportation or reprisal. What we're trying to do is address gaps in current regulations that are enabling this human trafficking to occur here in Georgia and Cobb County. While the state regulates and licenses massage therapists, many employees in these health spas and massage parlors are not required to be licensed. This can be front desk personnel, cleaning staff, or foot masseuse, people who just do the foot massage practice there. This creates an enormous opportunity for human trafficking, and to which massage parlors have been linked a lot. Under our current county ordinance, a background check is required for these unlicensed employees, but not a work permit. At the time of the application for the health spa license, they're supposed to submit the licensee information as well as a list of employees and their information for background checks. Most are not doing this or complying. And once the license is issued, the businesses are failing to keep us updated as required by existing ordinance. So this section is being updated to fill these regulatory gaps and provide the police department and business license division with the additional tools we need to address human trafficking in massage parlors and deter conduct that's harmful to the interest of Cobb County citizens. So the first part is the proposed amendments to existing ordinance 78-273. We would like to provide an improved mechanism for requiring these licensees to provide us these list of employees as is already required, so that we can ensure these background checks are conducted on all of their employees and contractors. Section 78-275, we're adding a prohibition to prevent employees from remaining on the business between midnight and 5 a.m. Normal operating hours are 6 a.m. to 10 p.m. So we're giving them time for cleaning and morning setup. But one of the things we've seen with human trafficking is a lot of these women in particular will be made to live on site, sleeping in the massage rooms and such. So this will help us with that some. Section 78-292, we're amending this to provide the enumeration of due cause for suspension or revocation of licenses, which was something that was somewhat lacking in the existing ordinance. Section 78-293, we're wanting to amend that to require certain signage be posted at health spas and massage parlors, such as their services and cost and so forth. Also to prohibit the use of locks on interior treatment doors to treatment areas, which, as we said, if you go to your doctor's office, you're in an exam room, they don't lock the door while you're in there, but you still have that privacy, and they can do the same thing here. This will help us when we go to inspect these places, so they aren't locking rooms to deny us access to see what's in there. Also, it would prohibit the presence of any person in possession of or under the influence of alcohol or drugs on such licensed premises. As I said previously, the code section was somewhat incomplete. It lacked penalties for violations, and it lacked a mechanism to suspend or revoke licenses once they were issued. So we are proposing an added section 78-298, which prohibits the employment of persons with certain criminal convictions within the last 5 years, and persons convicted of sexual crimes are required to register as a sex offender. This is very similar to the language in the alcohol ordinance. Also, this would allow for persons denied a work permit due to disqualifying convictions to appeal to the License Review Board, the same as persons who get an alcohol server permit. Section 78-299 requires that all employees and contractors not licensed as massage therapists by the state obtain a work permit in addition to the already required background check. So this work permit would be issued by the police department in conjunction with that. It establishes the term of this work permit as 12 months, the same as an alcohol permit, and requires the employees to have those permits available for inspection at all times while working. Again, the same as the alcohol industry. And then section 78-300 establishes penalties for the violations of this chapter. And section 78-301 provides for the conduct of hearings and appeals. These changes are the improved regulations for these high-risk businesses and will make the conduct of illicit massage activity much more difficult in Cobb County to protect our citizens and our property values and everything. Thank you.
Thank you, Sergeant.
Chips.
Thank you. I'll continue with the amendments to Chapter 78. The next will be pertaining to short-term rentals. And currently, the county code does not have anything to address short-term rentals in our code. So what we're proposing now is an amendment to Chapter 78, and I'm pulling that up. I thought I had it up, but here we go. Sorry for the delay.
No problem.
There we go. So what we're proposing is an amendment to Chapter 78 that would enable us to really just have a better grasp on short-term rentals and better respond to some of the issues that we have and some of the complaints that we receive. And as the board is aware, the primary concerns that we receive and the primary complaints that we receive dealing with short-term rentals are specific to parking, litter, and noise. Those are some of the most frequent concerns that are expressed. Short-term rentals are defined as rentals that do not exceed 30 consecutive days. So your Airbnbs, VRBOs, those types of rentals. And what we're proposing is to require issuance of a short-term rental certificate. And this would be a certificate that would be issued for the operation of any short-term rental. It would be issued by the business license division, and there would be one required for each short-term rental unit in the county. The application will require also to address the parking issue that specifies the number and location of parking spots. Most importantly, I think the short-term rental here is going to be required to have a short-term rental agent. So that is a person who is designated by the owner. It could be the owner, him or herself, but it's someone who is listed on the application as the local contact who will be available to handle any issues that may arise pertaining to that short-term rental. The name and contact information is to be readily available in the short-term rental unit as well as included on the application package. That is the contact who would be contacted if there are any issues. They would also be the one to accept service of any notice of violations pertaining to the rental. The standard conditions for short-term rentals are the same as they are for any other residence in Cobb County. It would need to be permitted. Short-term rentals are permitted in all residential zoning districts, so the R districts. They would have to have a valid certificate of occupancy, just as any building for human habitation is required to have. They would also have to meet all of the same requirements pertaining to single-family residences. So that's the parking with regard to having adequate off-street parking spaces. The occupancy would be limited just as it is for any single family residence in the county. This is not over and above what would be expected elsewhere. And of course, they have to adhere to all building, fire, and health and sanitation regulations. So the same regulations, there's certainly no higher standard held here for short-term rentals, but just ensuring that short-term rental owners are aware of the expectations in the county's codes. Any advertising for the unit would have to include the maximum occupancy of the unit as well as the number of vehicles that would be permitted and the local noise regulations. For enforcement of the short-term rental code, any complaints would be submitted to the code enforcement office, and the code enforcement would then notify the agent and or the owner. And they would be responsible for contacting the occupant to address the issue. Violation could result in issuance of a notice of violation to both the owner and or the short-term rental agent. And of course, the Cobb County Police Department, as the one who primarily enforces the noise ordinance, would have the authority to enforce the provisions of this section. For penalties, the first violation within a 12-month period would be $500. A second violation would be $750, and a third violation of the code within a 12-month period would result in any existing certificate being revoked, and any new applications for that property would be rejected within 12 months. So this really it puts the onus and puts it in the best interest of the property owner to ensure that the tenants, those short-term tenants, are being good neighbors. With regard to taxation, short-term rentals would be taxed just as any other facility providing lodging to individuals, and that includes hotel and motel taxes, which are currently being collected at this point by the platforms that host the short-term rentals in accordance with state law passed last year, as well as tourism fees and any other state and local taxes and fees. And the owner would be responsible for ensuring collection of the payment and also submitting those to state and local authorities as required by a state and local code. And the next piece will be Michael Brantley has an amendment to section 90-63 of the Parks Ordinance.
Thank you, Jessica. Good evening, Chairwoman. This is section 9063 restricted uses of our park facilities. This would go under item B, which was reserved, and it would be smoking in county-owned or maintained parks. It would be smoking or vaping shall be prohibited within the boundaries of any park, sports complex, recreation area, or facility owned, leased, or operated by Cobb County, including any open area within such park, sports complex, recreation, or facility. But this would exempt Cobblestone Golf Course and Legacy Links Golf Course from this section. Again, we took this from several cities and counties around. It was not necessarily a clear policy anywhere. So this is just something that we took from several ones to create our own. So this is what we're proposing, which is 9063B.
The next presenter will be Drew Ressler of Cobb County D.O.T.
Oh, just getting the right section. So first, relative to good evening, Chairwoman, Commissioners. Chapter 106, the revisions that are placed in front of you here are just clarifications and consistency with the major thoroughfare master plan that is adopted by the board that defines roads into certain categories, including arterial, major and minor collectors, and then local streets. This removes the designation of residential collector and residential subdivision street to make it a little bit more clear as to which roads and which classifications are required for each of the various requirements of the section. Also included in here, the intention of this presentation is to codify current practice of allowing for developers to contribute only when it is in the best interest of the county. For example, a development-related project that's required due to the traffic of the development. However, the project is not along the frontage of the property, or it is part of an ongoing DOT project and requires some additional funding in order to accommodate the development. The purpose of this section is not to allow for developers to get out of, say, installing a turn lane across their frontage when that is required. So the department, in addition to this language, would like to work with community development in the county attorney's office to make it very clear that this allowance for developer contributions for project-related improvements and contributions of such would only be when determined by the Board of Commissioners to be in the county's best interest. Curb and gutter, this section keeps much of the same language, but clears up some of the confusion that has happened in the past between curb and gutter. It identifies very clearly the curb and gutter and where each is allowed and in what situations. Within Chapter 110, you'll notice here throughout, I won't go through these in great detail, but each of these is looking to existing standards whether it's the county development standards, which are adopted by the board and establish these same items. In those cases, the information is currently duplicated between the code section and the county development standards. This clears it up so that it is just kept in one place, one area to revise should it need to be revised. This code amendment does not revise any of those requirements. It just clarifies that they are consistent with the county development standards on corner lots, on curves. It's consistent with the AASHTO design specifications, which is consistent with our current practice. And then moving into intersections, similarly is in accordance with the department's design specifications on exactly how intersections are designed per current practice. Same with jogs and pavement widths, that those are in accordance with standard county development specifications and standards, as well as curbs and gutters. Just some clarification on this, that curbing and guttering along public road frontage of the property, and the language there being consistent with the development standards. And then finally, again, some additional language in chapter 118 that clarifies current practice, that red curbs are only permitted on private property and not maintained by the county Department of Transportation.
All right, and the next code amendments will be to chapter 134. And this is the zoning chapter. This is the final amendments for the evening. So the amendments to chapter 134, the zoning chapter, were previously heard by the Planning Commission at their January meeting at the public hearing. The first section that was amended is section 134-1 definitions. We added a definition for automobile broker, which was not previously defined and differentiated from an automobile dealership. Clarified gross vehicle weight for a business vehicle. Added automobile broker office to the definition of other consumer goods and services. We also included definitions for semi-permanent cosmetic makeup practitioner and added that to the definition of community retail and neighborhood retail use. The next section is 134-7. In 2020, there was an amendment to add section 134-290 pertaining to the backyard chickens. At the time, the section 134-7 was not removed. There is some conflicting language here. So we were proposing to remove section 134-7. Those requirements are now included in 134-290. So there's some duplication and also some conflict there. So to clean that up. 134-121, and this is one that Drew has already talked about a good bit, and one that we've received a lot of public comments on, both at the Planning Commission as well as through the email over the last several days. The intent here is to clarify when a traffic study will be required for rezoning and SLUP applications. So this specifies those standards, and upon the recommendation of the Planning Commission, currently the language says a total of 1,000 vehicle trip-ins per day or 100 per hour. We will likely, at the Planning Commission's recommendation, change that to 750 trips per day or 75 per hour. And of course, Drew is going to be providing some additional definitions and clarification so that we're clear on exactly what that means and can ensure that we're achieving the intent of that code. I think the other thing that's key here is that it's going to require that the traffic impact study be presented to the Community Development Department at least 30 days prior to the Planning Commission hearing. And that way we can ensure that staff has adequate time to review that traffic study prior to it moving forward through the public hearing process. The Planning Commission held this at their January meeting, and we'll be hearing it again on February 1st, and we'll be bringing that additional clarification of the language to that meeting next week. 134-127. This is specific to appeal of rezoning decisions by the Board of Commissioners. There's some language in there currently about what happens whenever an appeal of the Board of Commissioners zoning decision is made to the Superior Court. That process has changed a bit. So it removes the language that's in conflict with the current process, and that was recommended for approval by the Planning Commission. 134-162, this would allow for acceptance of applications for the RA6 zoning district. This is something that has been allowed since about 2012, but was never cleared up in the code, so we're clearing that up. 134-203.2 RSL non-supportive residential units to allow for RSL non-supportive projects on a collector road with a minimum of 10 acres and a maximum density of 4 units per acre. This is specified in the purpose and intent section of that chapter of that section, but it's not carried forward into the standards. So again, there's just some conflicting language there that we are trying to clean up. 134-221.2, this is the redevelopment overlay district. Last year in 2021, we added an amendment that said no new applications for ROD would be accepted after March 1st of 2021. At this point, the proposal is to remove the ROD section from the code entirely, with the understanding that there is one property that does have that ROD overlay applied to it, and that language will continue to apply to that property. Section 134-230 light industrial district, as well as 134-231. These are specific to freestanding climate control self-storage facilities. These facilities are currently addressed in chapter 134-279 or section 134-279 of the zoning ordinance. That language will be stricken and the language will be replaced in LI and HI districts. And this provides standards for building height, floor area ratio, hours of operation, so forth, outside storage, recreational vehicles, all of those things in the LI and HI zoning district. This language mirrors the language that's currently in the ONI and NRC zoning districts, and it does require that a special land use permit be approved by the Board of Commissioners for these facilities to be constructed. The Planning Commission, again, held this one for the February 1st public hearing to have some additional clarification of the language. There was some great feedback that we received at that meeting from some area residents, and we also had an opportunity to meet with some of them last week and are in the process of working to clarify that language so that the protections the residents are seeking are still included in that language. 134-272, traffic and parking. The first one is to clarify the curb cut requirements for districts other than the R districts. Again, this is information that's included in the development standards, so cleaning that up a little bit in the zoning code to limit duplication and also conflicting language. Clarifying the process for approval of entrances and exits on state highways. That's something that is a function of the Georgia Department of Transportation. The county does not have an opportunity to participate in that process, so clearing that up. Prohibiting perpendicular parking on a public road, but allowing for approval of parallel parking by the Department of Transportation. Also allowing for parking on non-hardened surfaces in the R districts for lots that are larger than 5 acres. And of course, a number of those lots already do have existing gravel driveways that were grandfathered before this code was written. Under this provision, no vehicles would be permitted to park within 50 feet of the right-of-way unless they are on a treated and hardened surface, and no new or any new access to the public road would require 25-foot paved or asphalt apron at the public road. This is a request that frequently comes for a variance at the Board of Zoning Appeals, and one that is typically approved with no issues, and the 25-foot paved or asphalt apron is typically a stipulation that is applied to those requests. 134-275.1, the Military Airport Hazard District. This language pertains to the accident potential zone surrounding Dobbins Air Force Base. In 2018, there was a code amendment that gave the Board of Commissioners the leeway to really take into consideration existing adjoining uses, historical uses, and height, and other factors on a case-by-case basis in considering rezoning requests and applications within the accident potential zone. The recommendation here, or what's being proposed, is to remove that language that was added in 2018. And also the Planning Commission has recommended to change 134-275.145 to place the burden on the applicant to acknowledge the applicability of the APZ1, APZ2, or clear zone at the time of application. Section 134-29, I'm sorry, was there a question? Section 134-290, backyard chickens under 80,000 square feet. This language would be modified to clarify that the lot size is 2 acres rather than 80,000 square feet. So it's a difference of about 7,000 square feet, but just clean that up. And also change the section title to backyard chickens under 2 acres rather than 80,000 square feet. And then finally, in Article 6, the sign ordinance, Section 134-315 allows for one permanent sign per entrance and exit not to exceed 3 square feet and 3 feet in height on commercially zoned property, non-residential uses on residential property or apartments. And of course, non-residential uses on residential property would be things like schools and churches that are permitted on properties that are residentially zoned, but are not truly residential uses. So this type of sign would typically be your entrance or exit sign there at your access points. And then 134-323 allows for some additional temporary signage for non-residential uses on residential properties and apartments. The way the code is currently written, it does not allow for any temporary signage there, such as temporary banners and what have you. So this would provide some additional allowance there for temporary signage on those properties, but still prohibit things such as searchlights and inflatables on those residential properties that are perhaps would not be as appropriate as it would be on a commercial or industrial property. And also to limit inflatable advertising devices only to 4-lane roadways within the CAC or RAC districts. And that's the conclusion of our code amendments. The next steps from here, of course, this is public hearing number 1. The Planning Commission will review the items that they held at 9 o'clock on February 1st. Once we have this evening, we'll take the feedback that we've received through the board, and we'll also continue to meet with the Board of Commissioners over the coming weeks to get some additional feedback and input there. We'll revise the draft and put forth the new draft, the changes that are made for the February 8th BOC agenda. And then the public hearing for that, the second public hearing will be at 9 a.m. on February 8th. And that would be the first opportunity for the board to consider taking action on the code amendments package this year. And at this time, Chair, we would just ask that you open the public hearing.
Thank you, Jessica, and to all of our staff members that presented items as part of this public hearing. I would like to go ahead and declare this public hearing opened for those that have signed up to speak. As to go over rules for our public hearing, comments must be in relation to an item that has been presented, and comments are not to exceed 3 minutes. Kimberly, if you can let us know who our first speaker is.
Our first speaker is Janice Wolfschlager. Sorry. Janice, go ahead. Sorry about that.
All right. Can everyone hear me?
Yes, we can hear you.
I'm addressing Chapter 7843 having to do with the licensing and regulation of short-term rental, residential, like Airbnb, VRBOs, private rentals. I am advocating you to please approve that. And if you would, consider adding a notification requirement for surrounding residents. And the reason I say that is we live in Cobb County in an R20 zoned area. House next door to us was recently sold. And while they were negotiating, the buyers, a husband, wife, and parents, claimed to be buying it so the younger couple and their 2 small children could make it their new home. But the minute they closed, they turned it into an Airbnb without telling anybody in the neighborhood. The only way we found out was I asked somebody who was parked in the street if they were there to visit the new owners, and they said no, we rented this through Airbnb. I also found out none of the neighbors had been notified or were even aware of this, and now that they know about it, they are very uncomfortable with this situation. I know there's no current regulations on the short-term rentals, and that's what this proposal that Jessica Gwynn wrote is to take care of. I know it won't disallow such properties, although my neighbors would be thrilled if that happened, but it would require the owner to get a business license, et cetera. I think that's absolutely necessary, and especially those strong penalties against the owners for violations. But I also see online comments from people who currently own unlicensed properties all over Cobb County for this short-term rental, and they don't want licensing or regulations. They don't want you to dare make them liable for problems. They don't want to be fined for violations, verification of renters. They don't want the neighborhood homeowners to be aware of what they're doing. They want to continue using this property for free in their neighborhoods, in these short-term rentals with no regulations. A little self-serving, and it makes all of us a little nervous. It ignores our rights and possibly our safety, because we've all heard about these party houses all over metro area. And we are concerned that we were not notified. So I'd like to see that added to the amendment. And I'm asking you all, when this comes up, this proposed amendment comes up, to regulate and license the short-term rentals and to invoke any possible penalties into that, add, if you would, notification of the neighborhood. And when the amendment comes up for approval, I hope you vote yes for that adoption. And thank you very much.
Thank you. We can go to our second speaker. All right, Kimberly, are we queuing up our second speaker?
Yes, we had our second speaker move to public comment. So our second speaker is now going to be Randy Bobo, and we have a presentation shared by him. Mr. Bobo, go ahead.
Thank you very much. Good evening, Chairwoman and Commissioners. Thanks for your work and consideration on the short-term rental issue and my opportunity to share our experience living adjacent to one. Next slide, please. The purpose of the section and the code is to minimize adverse effects on surrounding residential neighborhoods and the neighborhood that the short-term rental is located in. As the first speaker mentioned, the effects are tremendous. Next slide, please. Next slide. Sorry, some of these have been cut out. Next slide. Okay. This depicts the property directly behind us as advertised on Verbo. It states it's 2,370 square feet and it sleeps up to 11. That would exceed the amount allowed under the square footage allowance as proposed in the new amendment. Next slide, please. This particular dwelling is on the exact same property behind our house. It's advertised at 1,300 square feet and it's advertised as up to 11 individuals. Next slide. Next slide, please. Next slide. This picture depicts one of the bedrooms in the second house that I indicated. And you can see that it has almost a dormitory look to it. Next slide. So here are the policies for both dwellings. No events, no parties, no large gatherings. And this happens all the time. Note also that there's a $15 or a $500 post fine imposed if they find out that parties have been happening and it's strictly enforced. It's great other than the fact that it only benefits the owner of the house. I have contacted this owner behind us before on this, submitted pictures. It didn't do anything for our situation, but it put an additional $500 into their pocket. Next slide. So since the property was purchased and repurposed as a short-term rental, these events have been held. Family reunions, wedding parties, and all-night parties. I'll let the slide speak for itself, but you wouldn't want to be this activity next to your home. Next slide. This slide depicts and illustrates multiple cars on the property, but not only on the property, but also in both directions on the street. The picture on the right is depicting car tracks that were left in the house next door to the two dwellings on the Verbo property because the people...
Mr. Bebo, I'm sorry, your time's up. Your 3 minutes are up.
Thank you.
Okay, our next speaker is going to be Joseph Santoro. And Mr. Santoro, go ahead.
Good evening, Chairman Cupid and Commissioners. I just wanted to thank you for the opportunity to provide our public comments today. My name and title, so I'm Joseph Santoro. I'm the Senior Policy Analyst with the Council for Quality Growth, and we're a not-for-profit trade association representing over 300 companies comprised of architects, attorneys, contractors, developers, engineers, financial executives with a vested interest in quality growth and development in the Metro Atlanta region and in Cobb County. We appreciate the opportunity to engage with Cobb County and staff at the release of the code amendments back in December of 2021. We have solicited feedback from our membership on these impacts and on these proposals would have on the quality growth in the county. We have spoken with several staff members and just want to personally thank Jessica Gwynn, the Community Development Director, Drew Resler, the Director of Transportation, and Fire Marshal Nick Dahl for addressing our questions and concerns over that time frame. And as Cobb County continues to work on the code amendment package, I respectfully request on behalf of the council our initial comments and recommendations. Our first is on page 23, relating to chapter 54, the fire protection section relating to pre-construction meetings. This was addressed in both the work session as well as the commission meeting today. And it is our understanding, and the intent of this section is to assist with projects for inexperienced commercial builders, building contractors, or when complex inspection situations arise during a plan review. And we did recommend adding provision that allows the fire marshal to waive the pre-construction meeting for applicants who have kind of demonstrated expertise and understanding of the Cobb County inspection process as well as the expectations. Fire Marshal Nick Dahl, I look forward to working with you on those language changes as well as Jessica Gwynn. Our next comment was on page 43, relating to chapter 106, streets, sidewalks, and other public places. We understand that, currently project-related improvements are determined on a case-by-case basis in the county. Drew did a great job of explaining this. We do have concern with the discretionary nature of the project related improvements in this policy change, and would recommend deferring further study before codifying these current practices. And it was good to hear that they're looking at revisiting some of those changes in the codes, and look forward to being part of those conversations as well. The next public comment we had was on page 51 and 52, relating to chapter 134 on the rezoning and land use permit applications. This is specifically relating to the impact study of the newly added language that would require the traffic impact study to be completed at the 30 days prior to a planning commission hearing meeting. We've talked with several members, and this is a strict in comparison to other counties in the region. And it takes at least 2 months to complete a traffic.
I'm sorry, 3 minutes are up.
Okay, well, thank you.
Our next registered speaker, Vicki Murphy Norris, she's no longer on the line, so we are going to move to our next speaker, who is Jill Flam. And give me just 1 minute to unmute her. Ms. Flam?
Yes.
Go ahead, please.
Good evening, Commissioners. My name is Jill Flam, and I'm presenting East Cobb Civic Association's recommendations on the proposed short-term rental code 78-407. In 2020, this code was brought forward, and we presented extensive comments and concerns to the Board of Commissioners. It was withdrawn. 2 years later, the majority of these comments remain unaddressed in the new code, and we have added additional ones. We have listed the specific sections of the code where our concerns are found in the email ECCA sent to you this morning. The following comments were brought forward in 2020 and remain unaddressed. First, this code still contains ambiguous language such as maybe, best efforts, reasonably available, and terms that are undefined such as accept service or violation. We recommend that these be defined in the code and not left up to interpretation. Second, we recommend all methods of communication be specifically defined between complainants, rental agents, owners, and Cobb County. Third, quiet enjoyment of property is not defined and therefore subject to interpretation. A backyard party during the day is allowed by code, but could potentially be a complaint for a rental property. We recommend that the same standards be applied as in the Cobb County Code for rental and owners. Finally, given that it is specifically stated that this is not a hotel or motel, why are they being taxed as one? With the requirement for a short-term rental license, we have additional comments and concerns. Does a $55 license cover all the work involved with keeping 4 Cobb County agencies up to date on these properties? Are there mechanisms in place to do this? Can all these changes really be done in 5 days? What does customarily present at a location within the county for purposes of transacting business mean with regard to the rental agent? In addition, we have concerns with How will the homestead exemption and senior exemption be handled on the property? It can still be an owner's primary residence. Right now, the code only addresses how many square feet per adult is needed to figure out occupancy. What age is an adult? What about children? According to these calculations, 780 square feet would be needed for 2 adults and a youth sports team. This situation has happened. Who will determine the maximum occupancy? If there is this discrepancy between the owner's calculations and the county, who will settle the discrepancy? And finally, how is grandfathering of a property handled with regard to zoning, fire, health, and sanitation? Does the property have to be re-inspected every year based on the current code? ECCA recommends that this section of the code be held for additional work. Thank you very much.
Our next speaker is Richard Grom. Go ahead, please.
Madam Chairwoman, Commissioners, my name is Richard Grom. I am the president of East Cobb Civic Association. In addition to the previous presentation, ECCA has additional comments. Article 7, noise. The proposed maximum of 65 decibels between 7 a.m. and 11 p.m. is too restrictive. The proposal of 65 decibels would make many activities under Section 50-257 illegal. For example, under the proposed changes, you would probably be in violation when using a gas-powered lawnmower, blowers, power washers, or even when children are playing outside. The proposed maximum of 60 decibels between 11 p.m. and 7 a.m. is also too restrictive. As proposed, you would probably be in violation while riding a motorcycle at night, or even laughing at an outdoor party after 11 o'clock. The decibel range is unreasonably low and the hours restrictive. ECCA understands that Lieutenant Vance Dupree of the Cobb County Police Department has recommended that the proposed changes be held and studied further for consideration next year. ECCA supports this recommendation. Chapter 90, Parks. ECCA is concerned about the realistic enforcement of this proposed code amendment. We are concerned that this has potential for tying up limited emergency resources, creating non-emergency 911 calls. Section 134-162 RA6. ECCA is in favor of RA6 being added back as an allowable code requested by an applicant. ECCA believes that RA4 should also be added back as an allowable code requested by an applicant. At the present time, there is only one code in medium density residential. Section 134-203 residential senior living. ECCA believes that the addition of the proposed words to section 134-203 residential living does not clarify the issue of required acreage as it relates to location of an RSL on a collector road versus an arterial road. ECCA recommends a rewording of all areas in section 134-203 related to this issue for additional clarity. Thank you.
All right, we have one more public speaker that originally canceled but is on the line, so I'm going to unmute Stacy Fuji. Would you like to speak? Okay. All right, that concludes all the speakers on the public hearing.
Thank you. Our public hearing is now closed. From our discussions earlier, we know that staff has been asked to please speak with commissioners about all of their questions and comments, suggestions with the code amendments. And commissioners, we've been asked to write down all of those things to be considered, not only for staff, but for each other, so that staff can make sure that all of our questions are answered, and so that we can know what are the potential modifications to the code that are being presented by one another. I just ask that we do that by Sunday, and certainly would ask for you to consider the comments that have been shared by our speakers this evening. With that, we will move on to the next portion of, I'm sorry, is there someone speaking? Oh, yes, thank you, Commissioner Gambrill.
Yes, I would like to provide some direction to staff. While this was not included in the current code package, I would like staff to review the outside lighting code for commercial projects. This has become an issue with LED lighting going up on commercial properties that is causing issues to adjoining residents. So I would like staff to review that for the board to consider possible amendments to.
Thank you, Commissioner.
Chairwoman, they cannot.
Okay, please have our county attorney please respond to that request.
Of course, we'd have to check and see if it was actually advertised for or not. For, I don't know, if Commissioner Gambrell was thinking about this round or maybe looking at it in the future.
Mr. Rowling, I would like staff to look at it. It has not been advertised. Therefore, I understand that, you know, staff would have to look at it. We'd have to advertise it and consider it. But due to the potential health, safety, and welfare of Cobb County residents, I would like it to be looked at and brought forward soon.
I understand.
Thank you. Are there any additional comments or questions before we close in light of our earlier discussion regarding comments and questions regarding the proposed code amendments? Okay, hearing none, we'll go ahead and move on to the next portion of our agenda, which is public comment.
Thank you, Chairwoman Cupid. As the board provides the podium for public comment, it's appropriate to review the related meeting rules regarding public comment. For those that are in the queue to speak, please state your name and if you're speaking on behalf of an organization. All comments should be addressed through the chair. Public comment is not a dialogue with the board, but an opportunity for speakers to provide their comments to the board. The comments should not be impertinent, derogatory, offensive, or slanderous. Statements made during public comment portion do not necessarily reflect the opinions of the board or the administration of Cobb County government. And I will keep track of the 5-minute timer for each person who signed up for public comment.
We have 6 people that have signed up for this section of public comment. Our first speaker is Lance Lamberton.
Hello, this is Lance. Can you hear me all right?
Yes.
Okay. Madam Chairwoman and Cobb County Commissioners, good evening. My name is Lance Lamberton, and I'm here on behalf of the members of the Cobb Taxpayers Association to speak to you on the issue of the mobility SPOST, and more specifically, the transit piece of whatever proposal you might put before the voters for approval. Even though you have not finalized a project list for the so-called mobility SPOST, we nevertheless know enough about it to know that raising our taxes to expand public transit in Cobb County is a non-starter for us and will be vigorously opposed regardless of the final projects list. There are literally dozens of good reasons to oppose it, but given this evening's time constraints, I'll focus on only one for now. You know, when a private business is looking to expand a retail facility, it does extensive marketing research to determine if expansion is viable and if the costs justify the investment. There is no reason why a county government should not do the same. But in this case, the county has completely failed to assess the need for a new transit SPOST, if in fact that need is measured by those who lack, quote unquote, decent transit options. For example, these following questions have not been answered. How many people lack transportation options? How can that number be verified? Who are these people? Are they in Cobb or are they people who want to come to Cobb? How does this demographic get around now without the transit SPOST? And finally, how much are taxpayers being asked to spend for each person in need? Are there not other ways to meet that need without spending up to $8.3 billion over 30 years? I don't think it is too far-fetched to claim that if we were actually to get accurate numbers on this score, that it might be far less expensive to give each one of these needy individuals a new Toyota Prius, although I'm not recommending that we do that. I am of the belief that the real driver behind such a potentially massive increase in spending is to accommodate an unspoken desire to urbanize the county. And what better way to do that, combined with changes in zoning laws, than to expand mass transit? I can think of no better way to essentially destroy the suburban character of our county. And I ask that you keep that in mind when you decide what you will put before the voters. Thank you.
Okay, our next speaker is Felicia Williams. I'm going to unmute her. Miss Williams.
This is Felicia.
Go ahead.
Hello. Okay. I would like to speak about the rental assistance. I had an appointment one day last week, and I was called 55 minutes before my appointment and told that there was no more funds, no more funding. So I was told not to come. And I had contacted other organizations as well, some which included Starseed, Sweetwater, Mission, Zion, Salvation Army, Latin American Association, and they're all pretty much saying they're out of funding. And they said, and one of the Latin American Association said and even when they do get funding, that there was no guarantee that I would get assistance. And it's a very lengthy process to keep trying to get assistance from other agencies, because they tell you it takes about 45 days from the date of your appointment. And you have to fill out forms online. You have to download your Social Security number, your driver's license number. Then you have to go to your landlord, and he has to do a landlord verification form, a lease, a current lease and ledger. So it's a very lengthy process, and they you send in like really personal information, like I said, like your social and your driver's license, and then you have to call you and tell you that they don't have any funds. Like I said, I was getting on my way about to leave when they called me. I had an 11 o'clock appointment, and I was called at 10:05 and told not to come because there was no longer any funds. And also, I just would like to say that I advocate for low-income housing or income-based housing. I don't feel that rent shouldn't take like 4 weeks of work in order to pay your rent. Maybe 2 weeks, and 3 is pushing it, but definitely not. You shouldn't. I don't think anyone should have to work a whole month to have money to pay rent. So I always suggest or advocate for low-income housing and income-based housing, because affordable housing really isn't affordable. What they call affordable housing right now isn't affordable. Someone making maybe $11, $12 an hour, paying $1,300 a month rent isn't affordable. Not when you have other utilities and health insurance and so forth. I Googled it, and according to the Atlanta Journal and Constitution in 2019, there was 21,830 evictions in Cobb County. In 2020, there was 10,814 evictions. And as of December 8th, there was 13,200 evictions. And these are hardworking people. Like, I went to work every day, but I was just making $11 an hour. And when you're paying over $1,000 rent, any little thing could set you back. God forbid if you have to fix your car or if someone gets sick, you miss a day. So those were my points for this evening. Also, I was paying on my account. That's another thing, but I got locked out of my account with my leasing facility. I was, they want all the money up front, but at first I was being allowed to make payments. But ever since the last payment I was allowed to make was September, so that's October, November, December, and January. So now that's 4 months going by with no payments at all. So the bill is still tallying up. Okay, and I'm trying to see if there's anything else. I'm sorry. Okay, I think that's pretty much it for me.
Our next registered speaker is Angela Coleman. However, she has dropped off the line, so we will move to the next speaker, who is Pamela Reardon.
Hello. Can you hear me now?
Yes.
Kimberly? Okay. Good evening. It is time to end all these emergency declarations and open up our public meetings. This whole thing this evening should probably prove that we are, I can't even get it on my WebEx. I have to do it through a phone. And there's a lot of people that obviously had to drop off because they can't wait this long. So there's no lines anymore in the cars down the road from where I am for the last maybe week or 2 weeks. So the testing is gone. Nobody is having to get tested, and I think the rates are down 40%. So you cannot vax the virus. I say it again. You just can't do it out of existence, and people need to learn about a better immune system and the therapeutics that work. And never in the history have I ever seen so much disinformation and lies from our government, not necessarily yours, but government overall. In the code amendments, I wanted to combine everything. I would like you to vote against unless they change the intent of 106-981B, because as I read it, if a developer needs to have a turning lane in a property that doesn't have enough space, they just need to pay fines or fees for that, but it doesn't fix the problem. So I want you to look at that and maybe fix it as well. I think what's stated in 134-121V8, similar problems with the wording. There should definitely be traffic studies. Lastly, the Unified Density Code. If you do some research in this, there's just too much multi-purpose buildings that are proposed, and now we see the new maps as of over the weekend, I guess, and last night. It's just astounding the request and the increases of high density in our suburban areas. I have a friend in Roswell who explained to me what happened when they brought in UDC 7 years ago. They initially thought that it was going to be a tool to simplify and cut down the time of developer applications for zoning and variances. And then they would virtually go away, but that was wrong. In the last 7 years, they even had to add meetings because developers don't stop and more variances were still needed. In reality, developers present one thing and do whatever they want to increase their profits by coercion, and they keep coming back for more variances. There seems to be no rules they can live with, and they want more variances. It became a public matter, an outcry. So the last election, most of the people who brought that in 7 years ago were voted out, and maybe that's a good thing. This whole 2040 plan is astounding to me. The zoning changes, the MSPLOSH works part and parcel with the, I'm using air quotes, need to update our comprehensive plan. Look at the map proposed, the higher density in Cobb County. This is why I support the cityhood, so we can stop the runaway zoning problem. There has been no real needs analysis showing real results. If any new sales tax is needed for transportation, as Lancet stated, we most definitely do not want to spend more sales tax and give it away to the ATL MARTA for the next 30 years, especially with an already high inflation rate taken away from our spending power. We have buses, and we have roads that are fine, and we need to keep it that way, and we don't need to spend any more money. So I say no to the comp plan. Thank you very much.
Thank you.
Our next speaker is Hill Wright.
Good evening. Hill Wright. Item number 12 on the agenda reads to approve an exchange agreement between Cobb County and Venture Communities to allow for proposed development Department of Transportation satellite facility off Leland Drive and authorized advertising of the exchange and subsequent closing. What it should read is to fix a colossal screw up made by vote of this board to allow residential development within the accident potential zone of the Dobbins runway, putting the whole facility at risk. It should read the proposal to fix this screw up is by selling out Cobb citizens by giving them a developer land the county now owns worth far more than the land the county will receive, making it all sound good by covering it up with a new Department of Transportation satellite facility. This is bad enough, but Cobb County's solution is to convey vested rights from one parcel of property to another, and to do so by bypassing zoning protections for the citizens of this county by potentially illegally doing this without a public hearing. This is just another example of bad zoning decisions made by 3 or 4 board members this past year that are making people think it's best to form a new city to get away from the county. The zoning votes by this board has been one of the biggest tools for the proponents of the proposed cities. This item needs to be tabled to allow residents of this county to fully understand what the county is giving away, and it isn't just land. It's been about 6 months since the flash floods left the county residents devastated without much help, except for those lucky enough to find records that prove themselves innocent. We've heard laughable stories made up to explain away things like 48-inch personal drainage culverts. Explanations would be laughed out of any court as ridiculous when weighing preponderance of the evidence. Explanations that are not reasonable and not what citizens of Cobb deserve. One lesson that should be learned from the flooding of September 7th is the county should be looking for the root cause of an issue. Walking away ignoring the fact that the county has no way to fund or manage stormwater after this isn't acceptable. Walking away saying pipes are open when there's a dam across the stream that the county approved is not learning. Trying to force citizens to disprove crazy theories or prove themselves innocent is not what Cobb citizens deserve. Cobb must develop a plan to go forward. Stormwater infrastructure might not be as sexy as the new transit taxes, but it can't be ignored or dismissed. Lastly, 3,000 trips to trigger a traffic report is way too high. That number needs to be much less and carefully weighed out and quantified. Thank you.
Our next speaker is Brenda Young. Brenda Young, go ahead. Okay. Okay, we're going to move on to the next speaker. Since we had one drop off earlier, we're going to move Miss Monica Delancey up. Miss Delancey, can you speak?
Yes, hello.
Go ahead.
Good evening. Again, I want to send out prayers to Julie Boyce for the passing of our former Cobb chairman, Mike Boyce. Mike Boyce was a true servant. Not only did he serve us in the military, but he chose to seek an elected position to serve the Cobb Countyans in his role as the Cobb chairman. Every district he represented, there would be times we would see him helping with the Keep Cobb Beautiful in all the districts. He supported different initiatives throughout the district. And of course, he supported We Thrive in Riverside Rental Association when we had to have the apartment complexes with their maintenance neglect. And he came out to listen to resident concerns. He also visited the Thrive Resource Center with the youth activities. So definitely Mike Boyce was a true Cobb County champion, and we should all be grateful to have graced his presence And also he supported my daughter Breon. He was so happy to hear of her going to college and seeking a career, seeking a degree in political science. And he would ask about Breon. And the last time I saw him was at a meeting in August of last year, 2021, at a housing coalition meeting. And again, he was still in his role of service, and he wanted to make sure that Breon finished college, and he would be so glad to hear that she's finishing in May of this year. So again, I just wanted to say, of course, I want to talk about the housing crisis. Of course, I want to talk about the rental assistance crisis. But I'm gonna yield, and just say and send up prayers again for Mike Boyd's family, and for Cobb County, and for everyone who had a chance to serve with Mike Boyd. Thank you very much.
I'm going to try one more time for Brenda Young.
Oh, hello. Yes. Hello. Hang on. Just a minute. I was trying to listen another way. Hang on. Let me.
Please turn that off. Yeah.
Oh, gosh. I apologize. I wasn't unmuted before, so I apologize. I guess I should have been on during the hearing part for the code changes, and I'm here to talk about the short-term rentals. And God bless you all for doing your job as Cobb commissioners and all of the people that are there this late at night. I have never attended a meeting. I apologize, and I've never been online like this, so I have a whole new respect for you all. So I will try to make this brief. I wanted to talk about Section 8H of the standard conditions, number 4, life, safety, and sanitation. A is the short-term rental occupancy, which says it will be limited to 1 adult per 390 square feet. As that's written, if I'm to understand it, is a property owner with a short-term rental of less than 390 square feet would not be allowed to rent it with this code in place. That could be a property owner with an apartment above a garage, a studio apartment with that might be 360 square feet, because the standard garage, 2-car garage is 18 by 20. And they wouldn't be able to rent for short-term rental. If that garage apartment were 20 by 20, that would only be 400 square feet, and you would only be able to have 1 adult in that apartment. In my opinion, respectfully, a requirement of 390 square feet for each adult is excessive. And it would be a hardship for property owners who want to participate in the short-term rental market. People staying in short-term rentals are usually staying for just 1 or 2 nights, and they don't need a lot of space. Sometimes they don't even do any cooking. The average hotel is only 120 to 140 square feet. A studio apartment, the average size is 300 to 400 square feet. An average 1-bedroom is 700 to 1,000 square feet, and a 2-bedroom is 900 to 1,150. Well, 1,150 square feet under these guidelines would only allow for 2 adults to stay in this property. Instead, it could accommodate 4 adults. So to me, the 390 square feet is, that may apply to your long-term rentals, but that does not apply in the short-term rental market, I think. And I know there's some problems with short-term rentals, party houses, excessive noise, and parking and litter. And I heard some of the other comments during this presentation. To me, this is a few bad apples spoiling the barrel. And I believe that the majority of our responsible owners, many who live on site with that garage apartment I mentioned, many may need the short-term rental income. This would impact a friend of mine, a retired couple who rent their studio garage apartment for $75 a night for a little extra income. And for a little company, they enjoy the visitors who come to stay with them. They love meeting new people, and they really do need the extra money. So I think we have to remember the other side to this. And I know you all want to somehow limit the number of people in a property and to deal with these bad apples. And maybe one way is to consider limiting the parking and be more strict about that. But remember that the average short-term renter is 2 adults, a couple most likely, staying for 1 or 2 nights. And we really don't need a lot of space. So I would do away with that 390 square foot.
Ms. Young, you're sorry, your time's up.
Okay.
That concludes the public speakers.
Thank you, Kimberly, for helping to moderate our speakers for public comment and also those for the public hearing. We are now moving into consideration of our consent agenda. Our consent agenda has items which are voted on in bank. However, there have been some changes to our consent agenda for this evening. And some items have been revised, as well as items 12 and items 14 have been moved to the regular agenda. Item 12 pertains to the exchange agreement between Cobb County and Venture Communities. That item is moved to the D.O.T. regular tab. We have also moved item 14, which pertains to the American Rescue Plan Act, to the Support Services regular tab. So commissioners, for this evening, I'm asking for a motion to approve the consent agenda as it has been revised and to authorize execution of the necessary documents by the appropriate county personnel. Is there? Oh, thank you. I made the motion. Are you willing to second? I'm sorry, second. That's okay. Is there any additional discussion regarding the consent agenda as revised? Yes, Commissioner Gamble.
So I know we had an agenda item number 57. Where is that going to be going in our agenda?
Yes, we will speak to that item outside of the consent agenda.
Thank you.
You're welcome. Well, let me clarify with yes, thank you. Yes, we will be considering that outside of our consent agenda this evening. Are there any additional questions with respect to the consent agenda? Okay, we have a motion and a second. Seeing there's no additional discussion, all of those in favor of supporting the consent agenda as revised, I've asked that you please raise your hand. Okay, I see the hands of all commissioners raised, including mine. So the consent agenda passes 5-0. Thank you, commissioners. We are now moving to our regular agenda. And before we get into that matter, Commissioner Gamble, we will now consider adding agenda item number 57 to the regular agenda. This agenda item is to authorize a request to the Georgia Department of Community Affairs for $40 million of funding allocated to the state of Georgia for emergency rental assistance established under the Consolidated Appropriations Act 2021, which was enacted on December 27th, 2020 as ERA1 or Emergency Rental Assistance Program 1. So with that, I make a motion that we approve the add of that non-agenda item as I just presented. Is there a second?
Second.
Thank you, Commissioner. Is there any discussion? Yes, Commissioner Burrows?
This is just to add it, and then we'll have a motion to approve and discuss.
Yes, we will consider this later in substance at the end of our other items for the agenda.
Okay, thank you.
You're welcome. Are there any other questions? Okay, we have a motion again to add this non-agenda item in a second. Seeing there's no further discussion, I ask that you please raise your hand if you support adding this to the regular agenda. Okay, I see 4 hands raised or 3 hands raised, including mine. Those of you who are not in support of adding this to the agenda, please raise your hand. Thank you. We have 1, Commissioner Gamble. So this motion passes 4-1 with Commissioner Gamble in opposition. Okay, we will now move into our regular agenda. The first matter will be brought by our county manager. And from the county manager's office, we will have our deputy county manager, Jimmy Giese, presenting this item.
Good evening, Chairwoman, Commissioners, County Manager. Our item this evening is to ask the board to vote on a proposed commission district map created based on the results of the 2020 U.S. Census. Every 10 years, as the census is prepared and released, the state of Georgia must go in and redraw commission districts, city districts, school board districts, and then they must be balanced out based on population. We have received a map from the Cobb delegation, which is included in your packet tonight, along with the population deviations. So at this time, we ask the board to consider approving the map.
Thank you for that presentation, Jimmy. Is there a motion for this agenda item? I move that go ahead, Commissioner Richardson.
So moved.
Thank you, Commissioner. I'll second it. Is there any discussion? Okay, yes, Commissioner Richardson, and then I saw Commissioner Burrow.
So Jimmy, just question, if this weren't to pass in today's meeting, what would that mean from a policy standpoint from the view of the delegation and conversely from the General Assembly? And I mean that from a procedural standpoint.
Good question. At tomorrow's Cobb delegation meeting around noon, the Cobb delegation will be voting on this exact map. So they will take a vote, whether it passes or not, we'll have to wait and see. But this was more of an endorsement vote by the Board of Commissioners. It is the responsibility of the state legislature to do this process, namely our delegation. So while we do not have a role in the preparation, the delegation will go ahead and vote whether we vote to approve or deny tonight.
Yes, Commissioner Richardson?
Just to follow up, so when the delegation votes on it tomorrow, what comes after that? Does it, what's the process?
Once the delegation votes on it, the chair of the delegation will then what they call drop the bill on the floor of the House legislature. It will go through a first reader process, a second reader process. It'll be assigned to committee. And then if it's approved in the House, it'll go to the Senate. Or the Senate will do the same process.
No. Excuse me. We need all mics to be muted except for the speaker, please.
And once it gets into the Senate can adjust borders, and then it goes back and forth between the Senate and the House until they come up with a version that is satisfactory to both bodies.
Do you have any additional questions, Commissioner? Okay, thank you. Commissioner Burrow.
Yes, I just would like to say that I've already gone on the record with emails to the Cobb delegation chair and other representatives, that I do not support this map. Thank you.
Thank you, Commissioner. Are there any additional comments or questions? Commissioner Richardson, yes.
So if this map then goes to the delegation, I understand that you said the Senate and the House, when they try to reconcile this through readings, is there at that point engagement that you've seen in the past with commissioners ongoing in that process?
That is very possible. I was not in the process back in 2010 when it actually came down, but from talking with several who were there was that engagement where they come back to the commissioners and there were some movement of the lines as long as you can stay within that 1% deviation.
All of my questions.
Thank you, Commissioner Sheffield.
Yeah. Jimmy, is it a requirement to come before the Board of Commissioners, or is that done just typically as a courtesy?
No, ma'am, it is not a requirement to be approved by the Board of Commissioners. This was a request of the chair of the delegation that it would show a sense of support for the map that the delegation drew.
Okay.
My involvement as a commissioner was limited when we went through redistricting as I joined the board after being elected in 2012. However, it's my understanding that the court actually redrew a map for Cobb at the time, and it was in flux when I came in, and there was not a map that was formally put in place regarding the 2010 census until 2016. And during my on board, there was still communication between the commissioners, at least encouraging the delegation to be mindful of our interests. At the time, I felt as if that discussion was somewhat one-sided. As I spoke to some members of our delegation, I was told this is our process and this is within our purview of how we will redraw the lines. Thank you, almost, but no thank you. I'm very pleased that they seem to be mindful of the suggestions that I shared, but I did not receive communication that made me confident about that. The only way I knew that they were mindful of is when I saw the actual map that was being put forward and was approved. I say that because that's in stark contrast to what I've experienced or from what has been shared with me about this process. I think it took a lot of leadership and mindfulness of our current delegation chair to reach out to each district commissioner and ask them for their considerations and to go back and try to draw a map that made little to no change. I'm not saying there isn't change, but he did his best to apply as little change as possible to our current map in consideration of commissioners' interest. However, Commissioner Brohl did state to the board in writing that she did have concerns about the map. And so it is not new for her to state that to us publicly. But I can state that the current delegation chair did speak with all commissioners and took, from what I understand from his communication with me, suggestions into consideration to not make any drastic changes, but to be not only mindful of that, but also to be mindful of some interest from elections to see if he could address any precincts that were split precincts, as that just is a little bit more of an administrative challenge than just having a complete district precinct in a commission district. And so I thank the current delegation chair, Eric Allen, for those efforts. Understanding it's not it doesn't reflect a perfect map where everyone has gotten what they desired. I do believe, again, with the minor changes that have occurred to the district compared to our current maps, this is certainly a step above what I saw during the last process, or what I experienced, not just what I saw, but what I experienced. Yes, Commissioner Gambrill.
And like I stated yesterday, and for the record again today, that mindful and open leadership was not shown to myself or my district prior to drawing of the maps.
Okay.
Representative Allen did show me the final map that he is putting forth. I did not have any input or say into it prior to seeing that. And while the initial changes did look minor, and as he said, it would, not pass the eye test, you'd have to look very carefully. The changes and impacts are greatly and have a big potential impact to the representation within Cobb County. Therefore, I do not support this map.
Thank you for sharing. Unfortunately, Representative Allen is not here this evening, and I don't think that hearsay is the best form of evidence. But again, from speaking with him and following up with Jimmy, I believe that conversations with each commissioner did take place. And at least from my understanding, even though he may have shared a map, that he would have still made changes where there were suggestions shared with him on any objections that you had, or that, again, with him trying to not just balance just one, but every commissioner's interests. And again, this is just, like I said, just in stark contrast to what my prior experience has been. Yes, Commissioner Richardson?
I just want to state for the record, my experience was pretty much the exact same. There was a draft map, and that's what was presented, upon which I could provide my opinions or thoughts. There was certainly nothing produced prior to, or my insight before presenting a starting point. And so starting point was drafted, that was what was shown, and that was what I gave my remarks on.
Mm-hmm. Thank you, Commissioner. Okay. Again,
I had my hand raised, but
I didn't see that. I apologize, Commissioner. Go ahead, ma'am.
No, that's okay. I basically was going to share the same sentiment as Commissioner Richardson, but she had already stated it. But the process for me has been the same, and I just want to go on the record for people to know that there were no meetings in advance of this map being rolled out. And I believe that we all received the same map and had the same processes in place.
Thank you, Commissioner Sheffield. I just wanted to share that I am leaning towards us supporting this evening, and would ask for your support in light of the meeting that will take place tomorrow and the ongoing meetings at the state to redraw district lines for not just our county, but for counties across the state. I think it leaves the county extremely vulnerable to not vote on something that reflects our interests with respect to a map. And I would much rather see us put forward a map that took into consideration each one's district with minor changes, and fortunately keeps each commissioner in their district, and again, involve feedback from commissioners, than for us to risk having something drawn without our input that provides a drastic change and potentially risk not including commissioners in their district. Now, again, as I stated before, as what was told very plainly to me when I first started as a commissioner 9 years ago, this is an act of the state. It is a gracious act to ask for our input, but it is in their court to determine However, this is an opportunity for at least for us to provide something for them to consider as they are making decisions, understanding that things could change. But I just think it's better for us to give them something to consider while those changes are being made than for us not to give them something to consider at all. And Commissioner Burrow, I know I'm very sensitive. I'm very sensitive to Commissioner Burrow's concerns. Being here 9 years ago, her district changed more significantly than any other district. So Commissioner Burrow, please know that I'm very sensitive to your concerns. And I recognize the issue then, I recognize the issues now. I would like to believe from my communications, even today with with Representative Allen, that he considered each commissioner as a commissioner, and this approach was not partisan, that he did what he could to balance the interests of each commissioner and the interest of our current district lines as drawn, and again, taking some feedback into consideration from elections regarding keeping the precincts whole and not splitting them with districts. But Commissioner Burrow, I'm very sensitive to your concerns. With that, you're welcome. With that, we have a motion and a second. Is there any additional discussion before I ask for the vote of the board? Okay, for those in favor of adopting this resolution as proposed, please raise your hand. Okay, the hands are raised of Commissioners Sheffield and Richardson and myself. For those of you who are opposed, please raise your hand. Thank you. Please note that this motion passes with Commissioners Burrow and Gamble in opposition. Thank you.
Thank you, Chairwoman, Commissioner.
You're welcome. Thank you, Jimmy. The next tab on our agenda is the Sheriff's tab. Please note from our agenda meeting yesterday that the Sheriff's Office has withdrawn agenda item 28 for consideration, which pertain to approving a contract for National Roofing Partners for improvements to their facility. Therefore, we will go to agenda item number 29.
Good evening, Madam Chair, Commissioners, County Manager. The first thing I wanted to do tonight was to send the condolences of Sheriff Craig Owens and his prayers to the family of past Chair Mike Boyce. And that also comes from every man and woman from the Cobb County Sheriff's Office. Our agenda item tonight pertains to the renovation of the muster conference room. The renovation that we're asking for will give us the ability to make it truly a multi-purpose room and make our operations more efficient. The work will be done by Crown Services contractors. They won the contract in a sealed bid. There'll be no impact or any ongoing expenses after completion of the space. The funding will come from the 2016 SPLOST in the amount of $320,442. And the sheriff is asking the Board of Commissioners to approve a contract with Crown Retail Services Incorporated, doing business as Crown Services Contractors under sealed bid 22-6626 for the renovation of the muster conference room located at the Cobb County Adult Detention Center in the amount not to exceed $320,442, and authorize the corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Thank you, Chief. With that, I'll move that we support agenda item number 29 as presented. Is there a second?
I'll second.
Thank you. Is there any further discussion? For those of you in favor of supporting this agenda item as proposed, please raise your hand. Thank you. The motion passes 5-0.
Thank you, Commissioners.
You're welcome. With that, we are now moving to the transportation regular tab. Please note that we moved agenda item number 12 from the consent agenda to the regular agenda, and therefore that will be the first item heard under the transportation regular tab item. And as a refresher again, that pertains to the exchange agreement between Cobb and Venture Communities.
Good evening, Chairwoman, Commissioners. Would like to echo the condolences that have been expressed by the board and Chief Register to the Boyce family and the sad passing of the previous chairman. With that, the department has 19 items on regular. Chairman, per our conversation, the department does request to pull agenda item number 41. That is the CTP, to allow for inclusion of a vision and value statement that would support the technical analysis of the provided comprehensive transportation plan. We would develop this plan or this vision and values in coordination with each of the board members and resubmit the item for BOC consideration at a later date.
Thank you.
So with that, we will jump into agenda item number 12 from consent. Cobb D.O.T. completes nearly 7,000 roadway work orders annually. To improve the department's efficiency and limit the amount of time in transit, the department has recommended construction of satellite facilities throughout the county. A satellite on Leland Drive would provide both budgetary and time savings by allowing DOT maintenance crews to spend more time maintaining the roadways. Therefore, the department recommends the Board of Commissioners determine that the exchange of property serves the best interest of the public, approve an exchange agreement between Cobb County and Venture Communities to allow for a proposed Department of Transportation satellite facility, authorize the advertising of the exchange and subsequent closing, authorize the corresponding budget transactions, and further authorize the chairwoman to execute any necessary documents for said purposes.
Thank you. I'll make a motion that matter of fact, that's a District 2 item. I apologize. Commissioner Richardson.
So moved.
Thank you. Thank you. Is there any discussion? I think I saw a hand. I don't know whose hand. Is there any discussion regarding this item? Okay, Commissioner Richardson, then Burrell, and I'm sorry if I missed anyone else. We'll just start there and then we'll go to.
I think Burrell beat me to it.
Okay.
Thank you very much, and thank you certainly to staff, to DOT as well for all of the hard work here. I think there are just some questions for clarification from a public standpoint that, and I'll just ask a few regarding the land itself. And I know that it's been stated that there's certainly floodplain on this parcel that being looked at, and wanted to know how that had been analyzed or looked at as a part of this particular swap deal and how that would interact with equipment.
Of course, and I see Debbie is on camera, so Debbie, feel free to jump in. But that was considered as part of the satellite facility analysis of determining with the remainder of the land minus the floodplain, would that serve the purposes of a satellite facility, and we determined that we would be able to use it for said purposes.
And in terms of the access for this road and the benefits that it would yield to your department, can you kind of expound on that?
Of course. So the primary benefit, just generally of a satellite facility is right now in a county that has 2,400 miles of roadway to maintain. I stated the 7,000 work orders earlier. We run all of our work orders out of 1890 County Services, which is fairly central, which is helpful. But when we consider the time it takes to get to the corners of the county, north, south, east, and west, it is significant amounts of time that is spent when our crews get in at 6, travel to a site. It may be an hour and a half before they get and actually begin to actually work on anything. And at times, we can have employees that drive past a particular work location, come to County Services, get in their work truck, and then drive back the way that they just came. So the satellite facilities allow us to be much more nimble and efficient and effective with our work product. This site, this area in particular, is an area of interest that serves that purpose. in that it is on the other side of Interstate 75, with I-75 bisecting the county and being such a large draw on commutes. Crossing I-75 for work orders, being on the west side, crossing to the east side is very challenging and time intensive. So the location is ideal. In terms of the particulars of this site, it is set back. Being a satellite facility is not something that we need prime location and prime frontage. It's something that we're very comfortable serving as a more industrial land use, one that is set off of the roadway, given that it's going to be primarily material stockpiles, equipment, and a small office. The site also provides a signalized access to Windy Hill via Leland that would allow crews to be able to get to various parts of Southeast and East Cobb, as well as to Interstate 75 for quick transit in the event of an emergency or should a particular work order need to be addressed.
Thank you for that. And those are my primary questions.
Thank you. Next, we'll have Commissioner Burrow.
Thank you. First of all, I just would like to say that when this zoning came to us and was approved, there was a concern over safety and Dobbins and those issues that that presented themselves when the zoning was approved. And that was May of last year. So this has been a work in progress to get this to be resolved. I wish it didn't have to come to a land exchange or whatever, but it has worked out for the best. And it gets the residential out of the APZ zones. And I would like for the county attorney to, I guess, explain to the public how the land exchange is, an equal transaction based on the properties, the values, and the acreage, and that kind of thing, and why it is does not have to be a public hearing or an additional zoning, because the land in question now is county property. If you could speak to that just for clarification purposes. And
of course,
without the county property, without the zoning that was approved now being where the county property was, it takes it out of the APZ zones, and that is residential, whereas the satellite office would be permitted in the APZ zone.
Yes, and an exchange of property is allowed in state law under 32-3-3. When we are acquiring, an exchange is considered an acquisition of property. So long as the exchanged property for the county property is of equal or lesser value, then this is an allowable transaction. Cobb County has had both of the properties appraised, and an independent appraiser has determined that the values of the property are equal. You will see in the documents, the Leland site has 4.04 acres, and the zoning approved them for 38 units on that parcel. The land that's being exchanged is actually 4.76 acres, the county property off of Terrell Mill, but it will only allow for 38 units as well. So our appraiser has determined that the valuation is of equal value and is allowed. The zoning that exists on the Terrell Mill County property is currently RM8 for condominium use. That is a use that the developer of the Leland site, it works for their development. So because of that, there is not a zoning hearing that is required. The zoning that's in existence is allowable for their development. The actual exchange does not require a public hearing under state law, and therefore it's allowed to proceed as we've done it here through an agenda item before the board at a regular meeting. Did I address everything, Commissioner?
Yes, ma'am, you did. Very thorough. And that is why we requested yesterday a work session to move this to regular rather than consent, so that, because it's not required to have a public hearing and it's not a rezoning, because it's already appropriately zoned, I felt it best to discuss it publicly, just so the constituents and folks that we have received emails from with certain questions, that this could be clarified, and I appreciate you doing that. Thank you.
Commissioner Richardson, before I come back to you, I just want to make sure I didn't miss any other commissioner, because I didn't see properly when all the hands went up. Were there any other commissioners that had prior questions other than Commissioner Richardson just raising her hand? Thank you. Commissioner Gambrill?
I don't have a question. I just have a statement that, while I agree with the comments given by Commissioner Burrell, this agenda item I cannot support, because we are essentially asking for a vote to approve expenditure of unknown funding from an unknown source with this land exchange to build this D.O.T. transportation facility. Agenda items typically always have a dollar amount assigned to them, so that way the board knows what they're voting on and what they're expending. Therefore, I cannot support this agenda.
Thank you, Commissioner Gambrill. Commissioner, yes, Richardson?
So the question that I have kind of tails on, and Debbie, is for you, but for the 2-year requirement from the state, that was another question that came from the public, where it says construction must begin within 2 years. And I know that I believe that there's some vagueness in what construction means, but can you just clarify what that 2-year, where it comes from?
Yes. Again, that's included in state law. And in order for the exchange to be considered for present road purposes, construction of the facility needs to begin within 2 years of the actual closing of the acquisition. Drew, did you have anything to add to that?
I think you covered it.
Thank you.
So I presume there will be, follow-up. I presume there'll be some type of follow-up agenda item on what that looks like.
Absolutely.
Yeah, I will note that satellite facilities was part of our biennial budget request, and be glad to speak more on that at a later date.
Thank you. Are there any additional comments or questions from commissioners? I'd like to share first just a thank you to many of the staff members who have been involved in addressing this matter, starting with you, Drew. Also, definitely with our Community Development Director, Jessica Gwen, who met with me and representation from Dobbins and with staff following the zoning decision. I'd like to thank, yes, also Commissioner Burrow, she raised her hand. She was there too, yes. Sorry about that. I'm running through my list, but yes, Commissioner Burrow was in that meeting. I've met with representation from Lockheed, from our chamber. We had a community meeting of about 50 people to talk about our relationship with respect to Dobbins, which is something I think that has been unprecedented outside of consideration of the J-List. And I'm not sure everyone was gathered at the same time to hear from the base and talk about our county interest and the base's interest in that site. I'd like to definitely thank Sharon with Support Services for her consideration of this matter, and definitely cannot forget our legal team. Debbie, thank you. Also, Bill, and I'm having a brain lapse right now.
May I say Keisha Pangburn and Pat Riley.
Thank you. Thank you very much. There were a number of people working together, and this is just the way that we get things done and how we handle challenges best is through working with one another. And that was a sentiment shared all along from the beginning with respect to zoning. Again, when this decision was made, the decision was made in alignment with the military hazard district as it stands today, and looking at what was being requested and the surrounding use and character of properties of the subject parcel. And has been shared many times before that the level of issue with this rezoning and the specific concerns were not perceived weighty enough for staff to object to this zoning. In fact, their recommendation was approval for this zoning. And this is not the first zoning that this board has had that has been in one of the accident potential zones. And so in light of that history and staff's recommendation, a decision was made that did not contradict the considerations of our military hazard district. As with any zoning, if there is concern from the applicant or from the community, oftentimes we do seek a forum to be able to address these issues. And a lot of these issues did not come to the attention to each of the commissioners, so we can fully understand the weight of their concern until after the zoning, in which we began again all of the meetings that had followed. And I think will result in us having a better relationship, a better understanding, and an ongoing ways of communicating as the group that met asked for us to meet at least on an annual basis. And it was interesting. I even had somebody say, can we meet more regularly than just one time a year? So that opportunity has always been with us and something that I think will help strengthen the county. With this particular matter, we are certainly fortunate that a number of stars aligned for the county to have a parcel that or property very close to the subject property. At the same time, you guys can remember from the beginning of the year at our retreat, D.O.T had shared with us their interest in putting a satellite, not just a satellite, but multiple satellite locations across the county. And so these, again, I don't think were considerations at the time of this zoning, but when we sought to see how we can address these issues to provide the best path forward in light of the concerns that came up, we're able to also take advantage of the opportunities presented to us at the top of the year to see what interests could be met with the county. And in alignment with our state code, we were able to address it in the manner that's being presented before you today. I wish I can say that we lived in a perfect world where everyone was perfect and no one ever did anything to ever make anyone upset and everything just happened the way that everybody expected them to happen. But that is certainly, we have not known that to take place in our personal lives, and that just is not how things are. But man, what a great opportunity it is, again, when we recognize that there is a challenge and we come together to solve it. And I would ask for our board to always see the silver lining in every challenge that we have, that there is an opportunity on the other side of it. And today we have an opportunity on the other side of this matter, no matter how anyone wants to address what occurred. Again, look at us being able to take something that, again, provided a challenge and now is providing a way for us to better serve our citizens and to protect the interests of the base as has been articulated. With that, before I make the motion, I want to caution us, board, I don't have the number in front of me right now, but we do have numbers of parcels that are within the clear zone and in our accidental potential zones. And I've asked for our tax commissioner to send me the valuations of those, because I have had significant business owners in the county ask for us to consider their property interests. And with the code that's being presented today, if we do not consider anything beyond what is the suggested policy interest for anything with an APZ or APZ1, where we would only limit zoning to industrial or public property, we will be significantly reducing the property interest of significant business owners within the county. And I've already been had contact with one of them that said that they want to be fairly considered as well for all of the investment that they've made here, and for them to be able to realize a return on their property so that they can better serve the citizens of Cobb. That was one of our, again, a very large and strong businesses here, and that is not the only one. So I know that there are strong interests with respect to this matter, but I, again, believe that the military hazard district provides an opportunity for balancing all of the interests of our property and stakeholders. And that what was done in that stakeholder meeting we had, that was done with the zoning decision. And that is what I think we will always continue to do when we have zoning. We will always balance the interest of our property owners, of our stakeholders, to make the best decision that we can. So with that, I'm very happy to see this move forward again as it is today. We've had a motion, we had a second, we've had very robust discussion. And for those of you who are in support of this agenda item as presented, I ask that you please raise your hand. And thank you, commissioners. For those who are in opposition, please raise your hand. Thank you. May the record reflect that this motion passes as it has been presented with Commissioner Gamble in opposition.
Very good. Thank you. Our next item, moving to the normal regular agenda, is number 30, is to recommend the Board of Commissioners approve change order number 1 final to the contract with Chatfield Contracting Incorporated. A savings to the project in the amount of $15,250.80 for drainage system repairs on Emery Lane, project number D2843. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Thank you, Drew. Please, the matter comes back to you, Commissioner Richardson.
So moved.
Second.
Thank you. Is there any further discussion? All those in favor of supporting this agenda item as presented, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve the concept report for the design of roadway safety and operational improvements on Old 41 Highway, state project number 0016410, Cobb County project number X2609, and authorize the department to proceed with the project.
Thank you. Commissioner Gamble.
So moved.
Thank you. Thank you. Any discussion? All in favor of supporting this item, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 2 final to the contract with D&H Construction Company Incorporated, a savings to the project in the amount of $68,461.30 for drainage system repairs on Heritage Trace Drive, project number X2276. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Richardson.
So moved.
Second.
Thank you. Any discussion? Those in favor of supporting this agenda item as presented, please raise your hand. Thank you. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with Advanced Sports Construction LLC, a savings to the project in the amount of $42,433 for drainage system repairs on Wolf Valley Court, project number X2288. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Burrow.
Motion to approve.
Second.
Any discussion? All those in favor, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 3 final to the contract with Baldwin Paving Company Incorporated, a savings to the project in the amount of $271,473.05 for intersection improvements on Hicks Road at Concord Road, project number X2307, authorize the corresponding budget transactions and authorize the chairwoman to execute the necessary documents.
Yes, Commissioner Sheffield.
So moved.
I'll second it. Any discussion? All right, those in favor of this agenda item as presented, please raise your hand. The motion passes 5-0. Thank you.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 2 final to the contract with Baldwin Paving Company, a savings to the project in the amount of $382,188.99 for roadway improvements on Riverview Road, project number E6040. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Sheffield.
So moved.
Second.
Thank you. And any discussion? All right, those in favor of this agenda item as presented, please raise your hand. Thank you, Commissioner Burrow. Your camera is off. Can you let us know if you're in support? Thank you, Commissioner Burrow. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with Glosson Enterprises LLC, a savings to the project in the amount of $121,540.86 for Ebenezer Road Sidewalk, project number X2743. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents. And I did also want to note that the savings from this project will remain in the district sidewalk funds.
Thank you. I'm sure Commissioner Burrow appreciates that. Go ahead, Commissioner Burrow.
Motion to approve.
Thank you. Second, is there any further discussion? All right, those in favor of this item as presented, please raise your hand. The motion passes 5-0. Thank you.
Thank you. Our next item is to recommend the Board of Commissioners approve a construction monitoring and flagging agreement with Rail Pros Field Services Incorporated, a consultant for Norfolk Southern Railway, for advanced transportation management systems, intelligent transportation system communications, phases 1C, 2, and 3A, project number X2502. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Hey, Commissioner Sheffield.
So moved.
All right, second, is there any discussion? Those in favor of this item as presented, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with C.W. Matthews Contracting Company Incorporated, a savings to the project in the amount of $36,573.11 for emergency drainage repairs on the exchange, project number D2869. Authorize a corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Richardson.
So moved.
Second.
All right, those, if you have any comments or questions, let's go ahead. You're good? All right, those in favor, please, of this item as presented, please raise your hand. All right, I see 1, 2, 3, 4, 5. All right, motion passes 5-0.
Excellent, thank you. Our next item is to recommend the Board of Commissioners approve change order number 2 to the contract with Glosson Enterprises LLC, a no-cost time extension through March 31st, 2022, for sidewalk construction on Hickory Grove Place Sidewalk, project number X2749, and authorize the chairwoman to execute the necessary documents.
Commissioner Burrow.
Motion to approve.
I'll second it. Okay, thank you. I'm sorry if if I hear a pause, I'm going to go ahead and hop in there. Is there any discussion? All right, those in favor of this item as presented, please raise your hand. The motion passes 5-0. Thank you.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with CMES Incorporated in an amount not to exceed $2,800,854.30 for West Atlanta Street Trail, Cobb County project number X2412. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Okay, Commissioner Burrow again.
Motion to approve.
All right, second, is there any discussion? All right, those in favor of this item as presented, please raise your hand. Okay, the motion passes 5-0.
Thank you. Our next item, number 41, was referenced as pulled, so we'll move to item number 42.
Okay.
Which is to recommend the Board of Commissioners approve project number X2707, task order number 1 to the 2020 master task order contract with Jacobs Engineering Group Incorporated, an amount not to exceed $141,626 for preliminary engineering design of Midway Road sidewalk, authorize the corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
Commissioner Gambrill.
So moved.
Second.
All right. Any discussion? All right, well, those in favor of this item as presented, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with D&H Construction Company as savings to the project in the amount of $5,625.80 for drainage system repairs on East Piedmont Road, project number D2853. Authorize the corresponding budget transaction and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Burrow.
Motion to approve.
Second.
Thank you. Any discussion? Those in favor of this item as presented, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve a contract with Advanced Sports Construction LLC in an amount not to exceed $226,150 for drainage system repairs on Leafwood Drive, Phase 2, project number D2867. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
Commissioner Richardson.
So moved.
Second. Any discussion? Those in favor of this item as presented, please raise your hand. The motion passes 5-0.
Thank you. Our next item is to recommend the Board of Commissioners approve change order number 1 final to the contract with D&H Construction Company Incorporated, savings to the project in the amount of $90,857.25 for drainage system repairs on Orchard Valley Drive, project number X22111. Authorize the corresponding budget transactions and further authorize the chairwoman to execute the necessary documents.
All right, Commissioner Burrow.
Motion to approve.
Second. Is there any discussion? We'll go ahead and call the, I'm sorry, excuse me. Those of you who approve this as presented, please raise your hand. Thank you. I see all 5 hands up.
Madam
Motion
Chair,
passes as presented. Yes, ma'am.
number 45 was actually District 2.
Okay.
46.
Thank you. There has been a renumbering here, which is why I'm a little pausing. Yeah, I'm pausing too as we're going through because the numbers of the agenda items we have were changed as the consent agenda was revised. So bear with me, and I apologize for that, Commissioner Richardson.
I'll survive.
Thank you. All right. We can go to our next DOT item.
Very good. Thank you. Our next item is to recommend the Board of Commissioners approve change order number 2 to the project number X2749, task order number 1 to the 2018 master task order contract with Low Engineers LLC. A no-cost time extension through March 31st, 2022 for engineering design of Hickory Grove Place sidewalk and authorize the chairwoman to execute the necessary documents.
Thank you. Now this is you, Commissioner Burrow.
Yes, ma'am. Motion to approve. Thank you.
Thank you. Is there a second?
Second.
Thank you. Any discussion? Those in favor of this item, please raise your hand. All right, the motion passes 5-0.
Very good. And for our final item of the night, just some brief context. Bob Callan Trunk Trail Phase 2 is a project that is funded through jointly by the Georgia Department of Transportation as well as the Cumberland CID. This project, the county has been managing the project as a locally administered project approved entity. And therefore, the D11M0 project number was set up as a contract mechanism just to pass through those funds, revenue received from GDOT and Cumberland CID to deliver the project. This particular item moves that out of the 2005 SPLOST into a general fund project. There are no SPLOST dollars being moved with this proposed action tonight. So with that, the department does recommend the Board of Commissioners authorize a transfer of the project budget balance for Bob Callan Trunk Trail Phase 2, Segment B, Cobb County Project D11M0 from the 2005 SPLOST Transportation Improvements Program Fund to the Capital Projects Fund, Cobb County Project number TR475, authorize the corresponding budget and accounting transactions, and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Richardson.
So moved.
Thank you. I'll second it. Is there any discussion? All those in favor of this item as presented, please raise your hand. Thank you. The motion passes 5-0.
Thank you so much.
Thank you for walking us through all of those agenda items for DOT. And you're welcome. And we will be going on now to the support services tab. Okay, with our support services agency, we just have one matter pertaining to information services. And I believe Kimberly Limley, will you be presenting this item?
Yes, ma'am.
All right, go right ahead.
Good evening, Chairwoman, Commissioners, and County Manager. Our item this evening is a joint item between the Police Department and Information Services to request the Board of Commissioners authorize the Purchasing Director to purchase a drone detection system from Aerial Armor under provisions of the Georgia Department of Administrative Services, GEMA, Homeland Security, Sole Source Contract Number SN-Sole Source-42200-30 in an amount not to exceed $110,000, 2016 SPLOST Project Technology Improvements Program X0020, and authorize the corresponding budget transactions.
Thank you. I move that we approve this item as presented. Is there a second?
Second.
Thank you. Is there any discussion? All of those who approve this item as presented, please raise your hand. Thank you. That item passes 5-0.
Thank you.
You're welcome. And now I understand the pause when we went to the support services tab. As recall, we did have an agenda item pulled from consent for consideration for the regular agenda, which pertains to previously appropriated American Rescue Plan Act contingency funding to be utilized for cleaning and disinfecting related services and supplies to the county departments as it relates to COVID-19. Sharon, will you be presenting this item tonight?
Yes, ma'am. Good evening, Madam Chair and Commissioners, County Manager. So to promote the continued safety of county citizens and employees, we're requesting tonight that the Board of Commissioners authorize the allocation of previously appropriated American Rescue Plan Act contingency funding in the amount of $125,000 for use by the Property Management Department to provide COVID-19 cleaning and disinfecting related services and supplies to county departments, and further authorize the corresponding budget transactions.
Thank you. I move that we approve this item as presented. Is there a second?
Second.
Okay, is there any further discussion? Yes, Commissioner Gambrill.
Just for clarification, we did change where the funding was coming from, correct?
Yes, ma'am. It says American Rescue Plan Act.
Okay, I don't have the changes, so.
Yes, ma'am. It does. It's American Rescue Plan Act.
Thank you.
Thank you. Are there any additional questions? All right. Those in favor of supporting this agenda item as presented, please raise your hand. Okay, I see all 5 hands. This item or this motion passes 5-0 as presented. Thank you.
Thank you.
Just give me one moment as I flip back to my regular agenda item tabs. All right, our next regular agenda items will come under Parks, and I will turn things over to Mr. Michael Brantley.
Good evening, Chairwoman, again, Commissioners, Madam County Manager. Our first item is for the board to approve a contract with Southern Sign Systems for installation of entrance and directional signage at the Maple House Complex. This is a 2016 Park SPLOST program improvement. The signage will dramatically improve the overall aesthetics and improve navigation throughout the complex. Southern Sign Systems was the low bidder at $99,400. Per Cobb County purchasing policies, Parks was able to negotiate fee and scope with Southern Sign Systems, and those negotiations resulted in a $9,304.50 reduction in cost to the final price of $90,095.50. We ask that the Board of Commissioners approve the contract with Southern Sign Systems Incorporated to furnish and install entrance and directional signage at Mabel House Complex in an amount not to exceed $90,095.50 under the 2016 Park Splash program, authorize the corresponding budget transaction, and further authorize the chairwoman to execute the necessary documents.
All right, Commissioner Sheffield.
So moved.
Seconded? Yes, is there any further discussion? All right, those in favor of this item as presented, please raise your hand. Okay, the motion passes 5-0, and thank you for letting us know about that reduction after negotiations. Good reduction.
Our second and final item this evening is to approve a contract with Outdoor Aluminum Incorporated for material and labor to install replacement bleachers under the outdoor arena at Jim R. Miller Park. The 2016 Park Splash program includes infrastructure and related improvements associated with the completion of the approved master plan. Parks received a quote under the TIPS USA National Purchasing Cooperative from Outdoor Aluminum Incorporated for $248,279. We ask that the Board of Commissioners approve the contract with Outdoor Aluminum Incorporated to furnish and install replacement bleachers at Jim R. Miller Park in an amount not to exceed $248,279 under the 2016 Park Splash program, authorize the corresponding budget transactions, and further authorize the chairwoman to execute the necessary documents.
Thank you. Commissioner Sheffield.
So moved.
All right, I'll second it. Is there any discussion? All those in favor of approving this agenda item as presented, please raise your hand. Okay, the motion passes 5-0. Thank you, Michael.
Thank you, ma'am.
Thank you. This now brings us, I believe, to our second public comment.
Everyone, I think actually the non-agenda item number 15, which has been added.
Yes, I have that here listed after the appointments, but we can certainly add that now and discuss the DCA item.
Yeah, completely up to you.
Yes.
Okay, why don't we go ahead and do that, because that would be typical. Commissioners, if you're okay, we're going to move the consideration of the addition of agenda item number 57 pertaining to the ERA funds to this portion of the agenda before our second public comment. Is there general consensus to do that? I see a couple heads nodding.
Yes.
Nodding. Thank you. All right. Thank you. I see at least 4. All right. With that, I will turn things over to staff to present this item.
Good evening, Debbie Blair with the Cobb County Attorney's Office. This agenda item is to authorize a request by Cobb County for a reallocation of ERA emergency rental assistance funds that Georgia had. Georgia has received over $990 million in rental assistance between their ERA 1 program and ERA 2 program. Because they were not able to expend more than 65% of their ERA 1 funding before September 30th, 2021, they are looking for local Georgia jurisdictions that have expended their direct funding to take a reallocation of the state's funds. Cobb received and expended all of its ERA funds, and in addition, it has expended all but about $1 million of the received ERA 2 funding that was directly allocated to Cobb County. We have a second tranche in amount of about $13 million that is still coming to Cobb County, and Finance has requested that those additional funds be directed to us, but we are not aware yet of when that funding will be received. The funding that is available through the state of Georgia, through the Department of Community Affairs, is ERA 1 funding only. These funds must, of course, be dispersed in accordance with the U.S. Treasury guidelines. And for ERA 1 funding, that requires that a COVID-related hardship must be verified. So as you might recall, ERA 2 did not require a COVID-related hardship, but the ERA 1 funding does. Again, we have distributed all of our ERA 1 funding and have been going through ERA 2. If the board does approve this allocation or request, we would have to go back to verifying a COVID-related hardship. This particular agenda item is simply for authorizing the chairwoman to request the funding from DCA. If the board does approve this and the governor's office does approve it, then a separate agenda item will be brought back before the board for acceptance and allocation of these funds to any service providers for distribution to Cobb citizens. I ask that you consider the authorization by the chair for funding through DCA, if there's any questions.
Thank you. I'll move that we support this agenda item as presented. And then if we have a second, that will open it up for discussion. And Commissioner Richardson, I see you. So if I can get a second, we can move towards discussion.
Second.
Thank you, Commissioner Richardson. Please go ahead.
Thank you for working on finding some more funds. As we know, the need is pretty great and we want to be able to accommodate that. My question is outside of the stipulations associated with the ERA 1 funds, what other restrictions come with this? Are there any time-bound type of restrictions or reimbursement type policies associated with it?
The ERA funding must be distributed by September 30th of this year, 2022. So we would have approximately 8 months to distribute whatever is reallocated from DCA. Otherwise, there's no additional requirements on these funds other than what Treasury has already, the guidelines already from Treasury.
And so whatever we are not able to distribute after, before 9/30, we send that back to the state?
Yes, out of this ERA 1 fund. Now, our ERA 2 funding that is coming, the approximate $13 million, that is, we have until September 30th, 2025 to distribute that. It would just be the portion that is allocated here for ERA 1.
And then for these funds, are we requesting that residents would go through the application process again, or are we keeping track of who has been approved against ERA 1 requirements in our system so that we can accommodate where that balance is, where that needs to be accommodated?
Our service providers, the 5 service providers that we have been working with, have been tracking. They put all of the applicants into a tracking system and have been able to follow that. So what we further ask is that if an applicant does receive funding from one agency, that it goes back to that same service provider. Because of course, for ERA 1, you can receive up to 12 months of funding. So if you were an applicant and received 3 months of ERA 1, you could receive an additional 9 months of funding. But again, we ask that the applicant go back to the service provider that gave them the initial funding. And of course, we do track.
Right. I guess just to provide a little bit more clarity, what I'm looking to know is for an applicant that received an approval but no funding, because we know that there's kind of that checklist where there were people that there was approval, they would have received it, but as you said, we've expended those funds. Would they then have to go back and reapply and go through the process again, or are they kind of in a waiting line?
The service providers do know know which applicants have been approved but not funded. So if the funding did come through, now again, I will caution in that if they were approved but not funded under ERA 2, they could not receive ERA1 funding if they did not have that COVID-related hardship.
Right, and that's kind of what I'm asking with that, and then of course knowing who would be approved under the ERA1 guidelines. I'm just looking at that subset. Okay, thank you.
I have a question.
Yes.
Debbie, you might have already mentioned, but what's the dollar amount that will be transferred to the county?
The request is for 40 million.
From DCA to Cobb County?
Correct. Now, of course, that's the request that's in the agenda item. I mean, if the board decided to do something different, you know, they could do that.
Yes, Commissioner Burrow?
Yes, just having seen this afternoon, I'm very confused. If we've used all of our ERA1 money, we haven't tapped into ERA2, or have we?
We have spent all of our first tranche of ERA2, which is approximately $7 million. We have a second tranche of ERA2 funding available to us in the amount of approximately $13.8 million, and that has been requested.
Okay, but I thought recently we have been referring people to DCA directly that had not gotten assistance through our funding. Through
Debbie?
the nonprofits that are working the ERA1 and 2 and the previous CARES Act. So,
Debbie, if I can respond, I'm sorry to that.
what?
Go ahead, Commissioner Burrow. I'm sorry. I didn't know that you were continuing. Go ahead. Commissioner Burrow?
Well, my question is, are these going to be directly, is the money coming to us from DCA, and then it'll be dispersed to the 5 nonprofits that are working the ERA1 and 2, or are they going directly to DCA, and are they talking to the nonprofits that are managing the ERA1 and 2 money from the county? How is this all going to correlate?
I'll just preface it and I'll let Debbie finish. The ball got started here today when I was contacted by the state to help them with the disbursement of these funds. They're responsible for dispersing funds to the entire state. And because of the limitations they've had, because of the influx of people who've been contacting the state, they reached out to us to see if we can help, because they know that as a local government, we could probably expedite the disbursement of those funds. When we received our ERA1 money, they received ERA1 money at the same time. And they were required to meet the same requirements that we were. And so they're just asking us, as opposed to them having to consider sending the money back to the state, because they are just slammed really by people needing assistance. And they recognize 9% of the renters in the state of Georgia live in Cobb County. They asked us if we can help to disperse these funds. I will let Debbie speak more about the process of how we would do it.
Right. These funds would, it would just be like a direct allocation. The process that occurs is that this reallocation would be signed off by the governor's office. DCA would then return to Treasury whatever amount that we request, and then that money would be directly allocated into Cobb's account. So it would be treated as a direct allocation of additional ERA1 money from Treasury. So we would be responsible for its disbursement and those kinds of things. And that's why I had said that there is indeed going to be a second agenda item that would allocate those funds out to the service providers, and the terms, just do an MOU just like we've done in the past.
Okay, but this would be $40 million in addition to all the funds for ERA 1 and 2 that have already been allotted and dispersed.
That is correct.
Okay, because the last report we had, they still had money left.
We have met with, we had a conference call, I'm going to say about 2 weeks ago, and I might have that timing a little bit off, but they have distributed all but 1 million of the ERA 2 funding, and that is committed to, CFR has a remaining amount of about 1 million, and that's committed to ongoing eviction cases.
Okay. Is any of this going to CDBG for their?
No, this would just be a request to Cobb County, just like the prior direct allocations we've received.
Okay, and since the service providers that we have in place will be dispersing this too, will they be the same requirements that they have with ERA 1?
The requirements would be the same for ERA 1. And then the board, of course, will allocate it under a separate agenda item to the service providers.
Okay, and they'll be able to match who they've already dispersed to and talk amongst each other with the money's just coming from DCA.
Right. The funds are coming from DCA, but it'll be Cobb's money, and we keep track of any applicants that we have already distributed funding to. So we know if they've capped out at their monies or if they are eligible for some additional funding. And there are several people that have indeed capped out.
Right. Okay, and I think you said this, but repeat the time frame of when this 40 million has to be spent, or
September 30th of this year, 2022.
Okay, and how much total did we have in ERA 1 and 2?
We have received and expended 22.8 million of ERA 1, and we have expended 9.2 million of ERA 2. We've already requested our second tranche of ERA 2 funding in the amount of 13.8 million. But again, we're not sure, we haven't gotten any word from Treasury as to when those funds will be in our account and available for allocation.
And what happens to the 40 million if September comes and only half of it's been dispersed?
Treasury will recapture it. They'll take it out of our account. Unless, of course, they decide that they're going to extend that time period, which, you know, they did extend the time period for CARES funding from the original back in 2 years ago. Craziness, but yeah. So, I mean, the Treasury could allow it to be extended, but at this point in time, there's no word of that. So we would anticipate anything would be recaptured that we did not expend from this reallocation if it's approved.
Okay, so the MOU will have to come back as another item. So we're just voting on accepting the money tonight.
We're voting on requesting the money. Yes. I'm sorry, I didn't hear if you said request.
Yeah, I said accepting. I meant requesting. Okay, thank you, Debbie.
Thank you. Are there any additional questions regarding this agenda item? Okay, we have a motion and a second, and we just concluded our discussion. For those in favor of this agenda item as presented, please raise your hand. All right, the motion, okay. We have 4 in support. Those in opposition, please raise your hand. Thank you. The motion passes 4-1 with Commissioner Gambrill in opposition. Okay, with that, we are now going into our second public comment.
There are no one, chairwoman that's on the list for public comment.
Okay, very good then. We will now then go into our appointments and bear with me.
With the new terms.
Thank you. The first one is Dr. Okay, I'll read. Okay. The first one is to approve the appointment of Dr. Carol Holtz to the Highland Rivers Governing Board for an initial term to expire on December 31st, 2022. Is there a second?
Second.
Thank you. Any further discussion? All right, those in favor of this agenda item as presented, please raise your hand. Okay, the motion passes 5-0. Our next agenda item is to approve the appointment of Pete Quinones to the Highland Rivers Governing Board for an initial term to expire on December 31st, 2023. Is there a second?
Second.
Thank you. Is there any further discussion? Those in favor of this agenda item as presented, please raise your hand. Thank you. The motion passes 5-0. And I move that we approve the appointment of Chinwe Okoronkwo to the Highland Rivers Governing Board for an initial term to expire on December 31st, 2024. Is there a second?
Second.
Thank you. Is there any further discussion? All right, those in favor of the motion, please raise your hand. The motion carries 5-0. I believe that takes us to the last portion of our meeting, which is for Commissioner's public address. And we will begin with that of Commissioner Gambrill.
Thank you.
You're welcome.
I have two speaking engagements this week that you're welcome to join us at. One is with the West Cobb Business Association, and then the other one is with the North Cobb Christian School is hosting the Realtors, so we look forward to meeting with everyone there. Congratulations to Cobb County for earning the highest level of certification as Platinum Level Green Communities. And again, my deepest condolences to Judy Boyce on the passing of former Chairman Mike Boyce. These are some photos that were taken at his party back in December of 2020. He will be greatly missed. And then while my slides are over, I have a question, and this is directed to our county attorney, Bill Rolling, and also to our deputy county manager, Jimmy Giese. I had sent several emails over the past 2 days asking this question. And I find it very interesting that our discussion that was had on agenda item number 12 pertaining to the district map and how it needed the votes of the board to allow the legislators to then carry it forward. Yet a member of the board has been going down to the legislator to make comments to the delegation regarding the cityhood movements. My question is how can this be happening without a vote of the board? The past 3 years that I've sat on the board, whenever the board has taken an action that regards a legislative action, there has always been a resolution or at least a informal vote taken prior to putting something forward to the delegation. So where is that policy? Is it a formal policy, or is it one of these informal policies that seem to be coming to light lately? That ends my comments.
Thank you. We will now move on to the District 2 Commissioner.
Open up my screen side by side. All right, so from the office, last year did a priorities tour where I went around and HOAs, et cetera. And so for the year, for 2022, we're doing the same thing, priorities tour for the month of February. So certainly if you are part of an HOA or organization and you want to make sure your voice is heard and that the priorities I roll out this year reflect what you're interested in doing, please schedule some time. Calendar is fully open and just go ahead and get it on the calendar. So the next thing that we have here, join myself and my cabinet member, Arjo Turner, for sustainability in the third stakeholders virtual meeting on January 27th at 7 p.m. This month, we'll be hosting Citizens Climate Lobby, a nonpartisan volunteer-led organization driving climate solutions with economic and social benefits for Georgians. Join the virtual event to learn more about CCL's work in the community and how you can get involved with the SEED program. Register using the QR code or visit the website d2cobb.com for the link. And certainly this is just an opportunity to hear what they're saying, hear what we would like to do, but we have a different organization host a different session every month. So this is the third one. Next one. So if you've been following, you know that we do the agenda previews before every board meeting, and it's really a chance to dig into what each agenda item represents or the history of it, and certainly what other commissioners are thinking around different agenda items. Normally we did this on Facebook Live, but with all of the technical issues, we switched it over to Zoom. So we had the first one last night, of course, and appreciate all those that attended and looking forward to continuing on Zoom. Everything went without a hitch. Community updates. Congrats, Eagle Scouts. I had the pleasure of going to Mount Bethel Christian Church and just recognizing Noah Green, William Sharrow, Billy Galtley, Chandler Cobb. And let's see, my notes are kind of cut off here. But really great time. And of course, our former commissioner was there as well. Franklin Zhao is the other one. So you can see their projects here. I also put it up on my social media so you can actually zoom into the pictures. But congratulations to the Eagle Scouts. Next, update on recycling bins. So due to a lack of garbage service providers and county resources, as well as a significant increase in the improper utilization of the recycling drop spots, Cobb County has made the difficult decision to close the recycling drop spots located at 2905 Library Lane, 3330 Sandy Plains Road, and 4400 Lower Roswell Road for now. Some other options to continue recycling include Main County Drop-Off located at 1775 County Services Parkway, Marietta, City of Smyrna Recycling Center located at 3475 Lake Drive, Southeast Smyrna, and ask your garbage provider to provide curbside recycling with your service. Our code states that haulers do have to offer recycling. However, we are working very diligently with members of staff to identify some short-term solutions as we all work together for those long-term solutions. With the demand, we certainly do. I think that's it. Yes, that concludes my comments.
Thank you. Commissioner Burrow.
Thank you. I'm not sure which slide's coming up first.
All right.
Okay, Cobb County Animal Services is hosting Big Love Adoption Special You can adopt your best friend for $20, any dogs over 40 pounds. And I hope there are no cats over 40 pounds. But this is going to run through Valentine's Day. So go pick out your new best friend. And then we have had some adoptions through our Superior Pets program. And this is a beautiful border collie that was adopted by Mr. Rockwell. And he served for 4 years in the Navy, and we appreciate his service and for supporting Superior Pets for Patriotic Pets. The next slide is another adoption of this handsome pit bull who is already bonded with Mr. Pickett. We thank Mr. Pickett for his 7.5 years with the U.S. Army and supporting this program by giving this fella a new place to call home. And this makes a total of 210 adoptions, dogs or cats. We're very saddened to hear the news of the loss of our former chairman, Mike Boyce. He not only was a 30-year career Marine veteran and served our country, but he also was a public servant to Cobb County and our state. So it's very, very sad news and totally unexpected from him falling ill just a couple weeks ago. So we offer our prayers, our thoughts, our condolences to Judy and his family. We will miss him greatly, and may he rest in peace. Also, a year ago today, we lost another great public servant, Judy Williams. She was my planning commissioner for several years on the board, planning commission board, and prior to that, she was a county employee in our planning division. She was a guru for zoning and BZA during her tenure, and we still miss her too and loved her greatly. So condolences to her son and family. And to other announcements, you can sign up for my newsletter, cobbcounty.org/Burl, and keep up to date on all the news in and around District 3 and the county. Thank you.
Thank you. Commissioner Sheffield?
Thank you, Madam Chair.
I believe they're queuing up your slides.
They are. I just have 3 tonight. I thought this would be a marathon meeting with the code amendments. Okay, District 4 news and updates. College touring season is on the horizon. Join Sting as the nonprofit hit the road to DC for its annual spring break college tour. Sting Inc. is a 501c3 nonprofit organization that was created in South Cobb for the purpose of providing mentoring and enrichment programs for youth between the ages of 11 through 18. The organization's goal is to make a difference in the lives of youth and encourage them to live productive and balanced lives. To register for the college tour, please register at stinginc.org, and that's stinginc.org. Next slide. Join me this Thursday, January 27th at 7 p.m. for a virtual community forum. I will discuss my first year in office, challenges and triumphs, and what's in store for 2022. The meeting is hosted by the Austell Community Task Force, Mableton Improvement Coalition, and the Powder Springs Task Force. Please register in advance at mableton.org/calendar. And if you would, with the next slide, please, if you would mute. Okay, perfect. We changed it. I just want to give a heartfelt condolence to Judy and Mike Boyce's family. I had the pleasure and opportunity to work with him several occasions, and he was just always in good spirits, a good guy, and he was a true servant, and he will be sorely, sorely missed. That concludes my slides, Madam Chair.
Thank you, Commissioner Sheffield. I echo the sentiments of the board that this was devastatingly sad news to hear about our former chair. As was shared, he was a man of our country, of our county, of community. You always saw him at some community event doing something to serve someone. And for those of us on this board know, he was a man of family. When he wasn't here, he was often talking about going to visit his grandchildren. And it's just absolutely unfortunate to see someone who's dedicated so much to this county, because when you're in this seat, the county is your life. It's very saddening for those of us that have worked with our chairman. And we ask that this community, this county, that we lift up his family in prayer at this time, and that we remember his service as we serve the county. The work we do every day is a lot, and particularly right now, commissioners and for our staff, you know, the pandemic and just the pace of things has just been unlike anything that I've seen here. And I want to make sure I say thank you to all of you. It takes each and every one of us to do this work, and we do a good work. And I know that some of the things that we deal with are tough, and I know that we don't always see eye to eye on matters. But I want to let all of you know that I see you, and I recognize that we are doing a weighty and great and a good work in serving the citizens of Cobb County. And I want, again, to just say thank you. As for comments made by Commissioner Gamble, I just want to share that for the time that I've been here, commissioners have always been able to go to the Capitol and speak on county matters. And that is not the first time that I've done so. There is no formal policy about it, but it is an ability that each of us have in representing the interests of our county. This is not something that I think is a bad thing for us to do unless it's very clear that they're representing a policy interest or position of this board. And again, as I've shared with you via email, and as our board knows, our goal is just to educate and to ensure that accurate information is being put before the public. And I appreciate staff being very responsive in a short amount of time and taking time to go down to the Capitol to again reflect their observations of conditions here in the county. That's not going to be the first time that that's going to happen this session. We all see the kind of session that we're having this year. And I ask for you, as I've talked to you during our one-on-ones, a lot is going on. I'm going to do my very best to share information with you as I have it. I've been asking staff when they get it, don't just send it to me, send it to commissioners. I want you to know what's going on. We need to be engaged and to be vigilant in representing and serving the interests of this county. Because all I can tell you, I know without a doubt, there is a great and weighty work for us to do, and we need each other. Right now, you know that there is the consideration of 2 cityhood matters going on this week. If you have the ability to attend and speak on observations that can help clarify information, please do. In fact, there's a delegation meeting tomorrow I just learned about. You can go to that. It's always good to have some kind of representation from our county. I've been asked to at least provide a statement with respect to the map that was on our agenda this evening. And what I share will be reflective of what we discussed here today. Again, I encourage your participation in doing everything that we can to best reflect serving this county and serving the constituents to the best of our ability. With that, I pray that everyone has a good night. Again, I lift up Mike Boyce's family in prayer. I lift up our county as well in our consideration for all that we have going on before us right now. And I hope that each and every one of you have a good evening. And I hope that you will join us for our next BOC meeting when we come together in the month of February. Thank you and good night.